find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. If we put in the time. Yeah. Good evening, come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening.
Hello, everybody. Happy Thursday evening. Happy jury selection evening. We got so much to talk about. Oh no, my camera is in green instead of blue, so it's just going to be focused. Actually, I kind of like that better. That means I can move to the left, I can move to the right, and it won't follow me. I like that. But
we're going to teach you how to do the Macarena still.
We had a lot of stuff happening today. Hi, Krisha.
Hey, I told Joe before we came on, I was like, I'm so sorry. Yesterday, I was so tired. And Joe said he crashed immediately afterwards. So I've slept most of the day today. I slept a good solid 12 hours. So I'm about as keen as I'm going to be. As you can be with Lori Daybell.
Right. With her sucking the life energy out of everything. Oh my gosh.
Self-care.
More today too.
Self-care. Okay. Yes.
Yeah, I got in a couple of naps even after I crashed last night. Like immediately after we were done, I still took at least one nap today, maybe two. I'm not divulging those secrets. Yeah,
who's counting? You're allowed them with Lori Daybell. I'm telling you, she is not only a destroyer of families, but she's a destroyer of energy. Yeah.
So she sucked more life energy out of everything today. So she was in court. I didn't go. It was an internal debate with me though. Like, what is the return on my investment? And it turns out it probably would have been better for me to have gone than not to have gone, but I'm getting ready to go through 2 weeks of trial with her plus jury selection tomorrow.
You're practicing self-care, which is what you have to do.
Yeah,
you do. I don't fault you.
Yeah. So we have documents that came down today. Plus we have Fox 10 Fox 10 was in the courtroom today, actually twice. We have two videos. There was
no media. And it turns out Lori talked about Carl. I was like, oh my God. That was interesting to see. It was just the court feed, which makes me wonder, is that the feed we're going to get for this upcoming trial versus court TV feed? I hope not, because it was horrible.
Yeah.
I uploaded it too.
I didn't even know there was a court feed for her hearing in front of Judge Green.
That's why I ask about the court front cameras, because they do record these things for themselves. So that's That's what I mean by that. Somebody had brought it to my attention during one of the trial live streams. So I was like, oh, what? Don't tell me about that. Because I want to know.
So do you want to watch that one first? Is that what we're going to go first? Yeah. All right.
I think so. That way, anybody who hasn't seen it yet, we can watch together and learn some things to snark about if we didn't. They weren't so obvious before.
Right. Always snark. All right. Judge Green. So she went to a different courtroom and she went in front of a different judge that heard her motion to dismiss Judge Boreski, so I don't even know for sure that if I had shown up in court today that I would have been able to find that courtroom, because there was almost literally nobody in that courtroom today.
And it was really quick.
Yes, it was.
So.
All right. So let's see. Make sure I got my volume all the way up. Let's go ahead and watch this.
Turned up.
Yep. 11 minutes and 22 seconds.
Yay. Yeah, they mentioned there was no media present. Yeah.
Virtually. Thank you.
Lori Vallow for the defense. And Pamela Hicks, advisory council.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't.
Okay, she just said she doesn't want to go on the record, but she's getting ready to, in a couple of seconds here, object to there being media in the courtroom. So,
and it looks like she was really relying on Pamela Abernathy right there. She was looking to her.
Pam Hicks.
Oh, Pam Hicks. Yeah. Abernathy is the other person.
Right.
Whatever.
Abernathy is the other advisory council, right? He's the dude.
This is the eye roller.
Yeah. Yes.
I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay.
Yeah.
Is there anything you wanted to put on the record?
No.
Oh.
All right. My thought is if they come in, we can address it. All right.
Everything's
The
so
court's,
funny to
this
her.
is the oral argument on Ms. Daybell's motion.
Say what?
I said everything's funny to her. She's
Right?
like I haven't, but now I'm focusing on her because I've seen this already, and you know how you focus on different things each time you see it, kind of.
Absolutely. Yeah. There's so many aspects, so many layers.
Yeah.
You never see anything, see everything the first time.
Motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply that the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion in this.
I'm sorry, can you pull the microphone?
I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Boreski and asked.
Okay, she filed the motion and she can't even put her thoughts together to present an argument in front of the judge.
I'm no one to talk about anybody being able to pull their thoughts together because I have a hard time doing it all the time. because of this hooker, I do believe. But yeah, it's she's really gathering her
Yeah,
thoughts,
I
trying to.
would have had my argument ready to go, especially if I'm locked in my prison cell 23 hours a day.
Yeah,
Like, I've had plenty of time to prepare for this.
one would think. She's a translated being, Joe.
She's trying to
Allegedly.
like put those brainwaves out there. I'm translated, I'm better.
Mhm.
I don't need to present an argument. Yeah, you do. And you haven't
Right.
yet at all in any of her trials. She has
Does
yet
it-
to present an argument for her defense.
So what I kind of gathered from this was like, did she use the right legal argument to argue this about Judge Boreski? The 10.1, I think they called it. I don't know. Just kind of keep that in mind.
And asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing. And
Wait, I absolutely was not doing.
It's the Book of Mormon prophet, not the biblical. Nephi is not in the Bible.
Oh my gosh.
Semantics. Right. You
And
gotta
especially
think in semantics for sure.
Mormon fringe cult semantics. I gotta get those down.
Mhm.
Like, I'm just
Not biblical.
Yes, no.
I remember Lee T
I didn't
sounding
even
off about
realize
this.
it until
Say that again.
I remember there was a commenter, Lee T, who was sounding off about that, and a lot of like in our live stream, and I think on Web Sleuths too. So I just wanted to get that in. Sure.
No, the Book of Mormon is not biblical. Yes, I can
Nope.
agree with that. Yep, I'm down with that.
until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team.
She just admitted how wrong she was when she accused him of not ever granting any of her motions ever. She just admitted that. Ever.
Yeah.
It's like, Dad.
And then Marshall Dove is saying, and then at band camp, and then. What it sounds like.
One time at band camp, right? Yeah. It's a story. She's in front of a new judge, so she's telling a new judge a new story, but it's an old story. It's an old story. It's the same old story.
That he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
God.
All right. Anything else?
Right.
Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Boreski applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions set the state as one have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Bresky from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also,
Oh my gosh.
along those lines,
Oh my gosh. She even gets the last word in this.
Yeah.
Like,
And it still has no merit.
yes.
matter.
Like, she still can't land the plane. She's still circling the runway trying to land the plane, and
Absolutely.
she can't do it.
Your Honor, that's one thing that I asked Judge Boreski, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I
Wait, what discovery has he denied?
Whatever
do
she's
we
made
even-
up in her damn head, I swear. No, I haven't seen anything about that. Have you?
The only discovery issue that I know of is the gray key from Gilbert PD, or
Which is
Chandler PD with
The
Charles.
previous trial.
Yes, the previous
Nothing to do
trial.
with this one. Right.
Nothing at all.
Yeah, this is today's hearing, Silver Fox. Yeah.
Right.
as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for a year and a half.
No,
And I'm
she
getting
hasn't.
them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell.
By the way, we're
Right.
auctioning off access to that rack belt remote control.
To the bouton.
Like,
You can zap her.
if I can figure out who is actually in charge of that remote control, I'm totally going to go take it in court, and y'all gotta post bail money for me.
I'll do it.
I'm gonna hit that.
I'll
button.
raise it. Yeah. Yeah,
But I
her
haven't
voice
been able
gets on
to
my
find-
nerves. It's her voice. It's the
It is.
no, Your Honor. Whenever she didn't get her way, and then today she's like, yeah, and I can't stand it. I can't stand her though. But that's just, of course, me. But she needs to say, in my opinion, he's biased against me, not just stated as fact. She does that a lot. She states things as fact.
Right. It's like she's in front of one of her parents saying,
But Adam did it.
Exactly. She's in front of mom saying, Dad won't let me go out with my friends tonight.
Yeah.
It's
Very juvenile.
totally, yes, juvenile and pathetic. It is
No merit. No merit.
Has no merit.
Fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me. And all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion.
That shocked me too. But that's how she acted with Brittany, who interviewed her, right? Where she was like, what? Like it was news to her. that Brittany said Judge Bresky seemed to be very fair with you, and she was like, "What? He was?" Like it was a news to her.
But she just said, "I thought he was unfair to me before it even started."
Yeah, where? Because we think he was overly too nice to you. Yeah. What the hell?
Oh my gosh.
Checks Lori's rap
because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial. And nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information.
Honestly, I think juror number 15 should have been called in by Boreski.
But that's as far as her knowledge. I don't know. Do you know? We don't know.
Know what?
Do they have to disclose if they, bring a juror in and get them under oath? And
oh yeah, no, they don't. Okay. No, that's
so.
A private matter.
We don't know.
Maybe he did. Right? No, we
don't. You weren't
know.
there, Lori. You weren't there
right.
if it did happen. But she's stating it as fact again.
Right. And she also misquoted the facts. He wasn't brought in front of the judge twice. He was brought in front of the judge 3 times.
Joe's keeping tabs. He has been, even before Lori, even knew about it. So, right? I remember you talking about juror number 15, and I'm just like, good Lord, I wonder what's going on with juror number 15. But
he and juror number 15 ends up in court filings.
Lori says, I'm sorry.
No, go ahead.
Lori Ann Good says, take notice of the change of this voice versus the voice later when she is talking to Judge B later in the afternoon.
Yeah, I've got the afternoon feed. I've got the afternoon feed pulled up. Yeah.
Oh, yep. Cool.
I'll watch that in a minute.
I'll take note of that.
Northwest makes a really good point. All 3 times, the state and the defense asked if they wanted him excused, and Lori said, no, I'm good with him staying on the jury.
There you go. She omits that part. Point. We're very good at that.
Yep.
Thank you, Northwest.
Great point.
Information prior to deliberations, it was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial.
Mom, Dad said I can't go out with my friends. I want a new ruling.
It didn't go my way, so this is why. It's obviously because I would shut the hell up because he is going to sentence her. She is really poking the bear right now. And I mean, for sure, I don't blame him. I don't blame him at all. I do hope he goes back and watches her interview.
Yeah.
With Brittany.
Thank you.
Yep.
Thank you.
Zero effects.
I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial.
Yeah,
that sums it
up.
up.
60 seconds sums up the entire thing for me.
It didn't go your way, and so you can't. It doesn't mean he's biased against you. It just means whatever you're pissed off. You're biased against him is what it is. You're projecting again, Lori. And like Insightful One said, the fact that she's representing herself is proof that Judge Boreski that he did grant one of her freaking motions, you know. Anyways, he said she could.
Partial, unless there's some other allegation of bias that's been demonstrated. I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel. But the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact.
Wait, what was she just doing with her face right there? Did you see
Who?
that?
No,
Lori,
I was looking.
I'm gonna back up. I'm gonna back up like 30 seconds.
Okay.
She does something with her hands to her face that is weird to me.
Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing. Some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right.
Judge is like, I don't know what you asked, but it must have been cray cray.
So what other feed does he keep saying there's a better video on another feed?
There might be. I don't know that I want to go back and like explore that right now.
But the audio sucked on that one, she says. So
right. Yeah, there's an afternoon feed from Fox 10 where she does go before Judge Boreski during or after juror questionnaire review.
Okay.
Pre-trial.
Yeah, it just looked like she was doing her. I call it a CSI because there's used to be a CSI show where the guy would take his glasses off real slow and dramatic, but yeah, she looks like she's cuffed, and it looks like she's taking her glasses off, putting them back on for dramatic.
Like 3 times in a row. Yeah. Dramatic.
Yeah.
Pause. Yeah.
Yeah.
All right. So this is the feed from Fox 10. So the volume.
She looks tired.
Yeah, she does. And who is that dude to her left? Because that's not her investigator. Is that Abernathy? That may be Abernathy.
I don't know.
I guess.
He has like a freckle on the back of his ear or something. Or they're dirty. I don't know. I'm a woman. This is what women do. We find all the little details to nitpick at, right? That's what we do.
That's probably why I don't have a woman in my life.
We point out all the things. It comes in handy in some occupations. I know whenever I went to be a mechanic apprentice, airplane mechanic apprentice, they really talked about how women were good with the little things because we're very observant and we point things out. So for what it's worth.
Oh my gosh, that's so funny to me for some reason. All right. We're going to play this. So the volume is really low. So you may have to turn up your volume, and I'll turn my volume down for me.
Maybe the captions too. That kind of helps when they're right.
Right.
She is cuffed though. She is cuffed here.
She is. All right.
Wearing her workout gel uniform there, where it's off the shoulder, and she's got like a little tank top on that's faded underneath.
She's showing a little strap.
That's for her girlfriend.
This is in Judge Boreski's usual courtroom. I can tell by the paneling on
The lighting
the
too.
box right there. Yes,
The
exactly.
lighting is really good in there.
Yes.
Depending on the aggravator. This is not a capital case.
I know it's not a capital case.
Turn it up.
And in normal capital cases, you don't have an aggravation phase either, right? Only in a
You
capital
are
case.
aggravated.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So
You saw
with
how
the
she looked at her?
statute, this charge only
Yeah.
being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, there's.
You
first
a
off,
tougher punishment.
the jury-
we're all okay. This is going to be loud because if you turned it up to hear her, we're all in an aggravation phase right now, Lori. We're all in
Yeah.
an aggravation phase.
Will
Just saying.
maybe do they have captions for that?
Let me see if I can find them.
in the initial phase doesn't determine whether or not it's a dangerous felony.
There we go.
Which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
Looking forward to guilt.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge,
Which it sounds like
the
it.
state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No,
They're just alleged aggravators.
correct,
The
You're
grand jury
planning on
never
it.
found probable cause for them.
correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
That's what I said.
Yes.
Lawyer Lori. It's not
She
rocket
does.
science. It's not brain surgery, but she doesn't get it.
She does, Carolina. She does have different voices for different folks or whatever. And I think her hair looks lighter in this because the lighting is so much better in Judge Boreski's courtroom. It's brighter in there. You can tell. So
It
that
is.
could be a reason.
Yeah. Well, because the room is smaller, it may be the same lighting, but the fact that the room is smaller, that the courtroom is smaller, makes the lighting more
Yeah.
intense. Yeah.
Could be a light right over her head for all we know. I don't
Yeah.
know. I'm just trying to figure out different ways that rather than just saying it's because she's got hair box colors in there or something. I don't want her to have anything. But I think it's interesting how she talks about this right here, the aggravating factors. And until just now, she's like, so if I'm found guilty, no, when you're found guilty again is how I look at it, because there's so much, even if it's just circumstantial evidence against her, it's a lot of evidence against her, not to mention the other convictions she's already acquired. Okay. And there's even more evidence than that, than what's been presented in court. And it's damning.
And that's the whole reason why she stipulated in the first trial was
She
so
wanted to
that
hurry up.
well, she didn't want victims to come in and make a victim impact statement.
Right. She was
wanted
already
to-
like trying to just smooth over it real quick, gloss over it real quick. That's what it looked like to me, because it was just like, you're guilty. Then they pulled the jurors, and then that was it. It was just so minimal.
Yeah.
Like
She
I don't know.
she did not want the aggravating factors to be presented in evidence in court. She didn't
Yeah.
want victim impact statements. She didn't want your mom getting up there and talking about how
Mhm.
she was hurt by this, or your uncle
I
Jerry,
know
right?
it may not be relevant, and it's no way to really prove it. But the fact that the crime with Uncle Charles could have been done in front of the presence of minors just seems like that would be an aggravating factor. But I understand. We don't know. because we were not there. So we don't know if they were or not. And they're not here anymore, and just all the things. So
Right.
just usually, because like I think in domestic violence cases, if it's done in the presence of a minor, it's a big deal, Should be, if not.
Yep.
That's
I
true,
know.
Gritty Grit.
What do we got?
Gritty Grit had said, as Kay said, there's a ton of evidence against her.
Right.
Yeah. No, but I saw a ton of evidence against you that said you did.
Yep.
You go, Mom.
Okay.
Yeah, that's Abernathy.
Okay. She gets on my nerves. It's just a dark spot under his ear, it turns out. It's a shadow.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases.
In this one. Capital.
Mm-hmm.
I know in capital cases, they call it a Cronus hearing, but
You should know.
non-capital case.
The Crypt Keeper is good. Accurate.
He's whispering in her ear again as to legal details. And she could have avoided all of this if she just had agreed to legal representation.
Nene G says that's a 4.3 dark spot. I'm sorry, it's just funny. And probably accurate. If not, it will be by the end of this trial. Because she's gonna be convicted again, and it's gonna be everybody else's fault except for Lori Noreen Cox.
Oh, that's the best name for her. That is the best name.
Her birth name.
Yes. Yes.
Her government name.
Yes.
I don't know, Squeaky Will. That would be interesting. I've talked to Mark Means.
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16.
Speaker.
Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well,
Yeah, Lawyer Lori.
I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime.
I pulled it up.
Typically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family.
Well, this is the one time. This is the one time that the victim didn't die.
Right.
But there are 14 other factors, or however many.
Yeah, I pulled it up.
that do
just
apply.
That is. Oh my gosh. Every time I go live, amending charges and defects in the charging document, it says prior convictions and other non-capital sentencing allegations, challenges within the time limits of Rule 16.1b. The state may amend an indictment, information, or complaint to add allegations of one or more prior convictions and other non-capital sentencing allegations that must be found by a jury. And it's highlighted. It says a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. It says other things, but I don't know how far you want to go into it.
Keep going if you want to.
Okay, it says be altering charges, amending to conform to the evidence. It says a preliminary hearing or grand jury indictment limits the trial to the specific charge or charges stated in the magistrate's order or the grand jury indictment. Unless the defendant consents, a charge may be amended only to correct mistakes of fact or remedy formal of technical defects. The charging document is deemed amended to conform to the evidence admitted during any court proceeding. Nothing in this rule precludes the defendant from consenting to the addition of a charge as part of a plea agreement. And then, it says C also, and there's D, but they're very short. Amending to conform to capital sentencing allegation challenges. I don't think we even have to read that, right? Because it's not capital.
Right.
And then, D, yeah, they're not seeking the death penalty. So D, it says defects in charging document. A defendant may object to a defect in the charging document only by filing a motion under Rule 16. And that's all it says. And this comes from Westlaw, Arizona Court Rules. If anybody wanted to check it.
Okay.
I am no lawyer, obviously.
Neither is Lori, but she is now.
Yeah, true. True. What hearing is this? Where'd you find this one hearing? Because I'm gonna pull the transcript and I'm gonna run it through.
Okay. Well, this is Fox 10. This is the afternoon hearing.
Gotcha.
So this is, I think this is after jury selection.
Okay.
And let's see, we're 18 minutes in to.
I'm just gonna grab the whole transcript.
There you go. All right.
Defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that?
Oh my gosh. Wow. She just flips it around. She's such a narcissist. She immediately flips it back on the judge. He says, which of these? Problem. Yes, exactly. Which of these, he says, which of these do you feel like you may not have been convicted of in the last 10 years? And she knows she has been, so she can't argue that. So she says this instead. Oh my gosh.
Jury to make that determination.
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty, for example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreaux.
Wow. Wow. I think this is the first time that I have seen Judge Boreski refer to Alex as your brother. And he does it he does it in such an intimate way that I'm a little bit taken aback. Not in a negative way. I'm just saying, like,
Yeah.
Judge Bereski knows this case. He knows the facts of the matter. He knows the facts that occurred when Charles was murdered. And
He was
Alex
there for the
murdered.
trial, yeah. He saw the evidence. True.
Yeah. Like,
And
this is
go ahead.
I was just going to say, this is a very intimate way that Judge Bereski words this response to her. Your brother. I don't know that he's done that before, that he's called Alex your brother.
And I like, whenever you find a point, or whenever this is over, however you want to do it, I took the transcript from this very hearing and I said to my chat GPT, I was like, analyze the transcript and point out any narcissistic tendencies Lori Vallow Daybell may have. There's a whole, yes, I love doing it like that, because it's like, oh yeah, all the ways.
Let's watch a little bit more of this video, and then
it ain't going nowhere.
It's not.
Hey, let me
But
see.
I just found it impactful that he says your brother multiple times.
It's just like Lori in the trial saying, my husband, my husband, my husband.
Exactly.
But it's also a way for her to like claim ownership, so to speak. And it's also a way for her to distance herself by not saying his name, because her husband, like Megan sang about before in a spoof kind of song that she wrote, or that she wrote in accordance with Lori's shenanigans, so to speak. And she said, your husband is on death row in Idaho, because that's where your husband is, that's your husband, basically. I think it's good.
She the hoe. She the hoe.
She is the hoe.
And so he's doing the reverse of that, though, in this, which to me is empowering, because so she took possession of Charles in the last trial by calling him my husband, my husband, my husband. And now he's assigning possession of Alex as her brother, her brother, her brother.
Exactly.
And that's
really
powerful.
Interesting.
Yes.
Because I've been analyzing other things from the Gilbert Police Department FOIA report, right? And asking kind of the same questions with Melanie's about ways that she's distancing, the ways that, I mean, it is damning, y'all. It is damning. When I run these things through that filter, that chat GPT, I mean, it's not trying to give me things that I know, it's pointing out things that, it's a computer, so I just find it interesting. Very interesting.
Yeah. Computers should be objective, right?
Right.
Like way more than we're able to be as human beings. Yeah.
Human feeling. As far as right now, allegedly. They may become human in future, but just saying right now, I'm helping it. Lord.
Again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreaux. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice.
As an accomplice.
Right.
If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So,
right.
I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I say
I
when.
understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay.
All right. 13.5B talks about amending the charge or the indictment. Okay. Your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause.
Correct.
Secondly, as to the allegation that it's a dangerous offense,
I'm going to
the
address
grand jury
that
did
just
make
a second.
finding because that allegation was included in the indictment. that
If
it
I
was a
can
dangerous
pause.
offense.
Let me
So
find
there has been
pause.
probable cause.
She's not fit to represent herself.
Mm-hmm.
So she was declared competent by 2 different doctors
Yep.
before her December hearings, and
Before
in
he
her
granted
December
one of her
hearings.
motions to let her represent herself.
Right. So December 5th, 2024, she was declared competent to stand trial. December 6th, 2024, she was granted the motion to represent herself. But here's the thing. Was she competent to assist in her defense if she represented herself? Like, it's a thought. Like, I mean, I have questions.
I pulled this up too.
Okay. Yeah.
It says an attorney could have helped Lori Vallow Daybell significantly in this particular hearing by providing clarity, legal expertise, and strategic advocacy. Here's how. 1. Understanding and applying legal rules correctly. Rule 13.5, challenging sufficiency. An attorney would understand the nuances of Rule 13.5. They would likely recognize, as the judge pointed out, that this rule primarily applies to challenging the legal sufficiency of the charges in an indictment or amendments to those charges, rather than generally entitling a defendant to a pretrial probable cause hearing for all alleged sentencing aggravators that weren't individually found by a grand jury, especially when the grand jury did find probable cause for the main charge and the, quote, dangerous offense, unquote, allegation. An attorney could have explained to Lori that alleging aggravators for sentencing purposes is different from amending the actual criminal charge she's facing. Number 2, clarifying the purpose and necessity of an aggravation phase. So Lori repeatedly expressed confusion about why an aggravation phase was needed if the sentence was fixed and the crime was already deemed, quote unquote, dangerous. An attorney could have explained that the legal precedent, like the Blakely case the judge mentioned, requiring a jury, not a judge, to find facts that could potentially increase a sentence or affect its nature. They could have also explained why the dangerous offense, quote unquote, finding, even if included in the indictment by the grand jury as probable cause, still needed to be proven to the trial jury beyond a reasonable doubt in a separate phase. They also could have explained that even if the length of the sentence is fixed, findings on aggravators can have other legal implications or are pursued by the state for a complete record, especially to, quote, cover bases, unquote, for potential appeals, as the prosecutor stated. An attorney could have helped Lori understand that her personal assessment of the phase's utility, probably nothing in reality is what she said, doesn't negate the state's right to proceed or the legal requirements. Damn, it really goes into this. 3, framing arguments more effectively. Instead of repeatedly and somewhat combatively, I did not put that in there. It did. Insisting on, so all I did was feed it a transcript. Insisting on her interpretation, an attorney could have made a more structured, legally grounded argument if any part of her concern had merit. I didn't say that. It did. Example, if a specific aggravator was genuinely without any factual basis or proper notice, a different type of motion might have been appropriate. They would know when to press a point and when to accept the judge's ruling while preserving the issue for appeal rather than engaging in a circular discussion. Number 4, advising on realistic expectations. An attorney could have advised Lori that she was unlikely to succeed in demanding a probable cause hearing for every sentencing aggravator in this non-capital context based on her current argument. This would manage her expectations and potentially save court time, right? Number 5, strategic decision making. Regarding her statement, quote, okay, then I don't want to have an aggravation phase either, unquote. An attorney would advise her that she likely cannot unilaterally opt out of a legally required phase of the trial if the state chooses to proceed with it. They could also explain the implications of her not attending, as the judge pointed out. Last one. Number 6, addressing other concerns more productively. For issues like the headsets or handling Idaho trial testimony, and an attorney could advocate for her needs more formally and perhaps negotiate solutions with the prosecution and court in a way that a pro se defendant might struggle to achieve. In short, an attorney would have brought a deeper understanding of criminal procedure, the specific rules and case law at play, and the ability to articulate objections or concerns in a legally more focused, less repetitive discussion, and would have helped Lori understand the legal realities of her situation regarding the aggravation phase, even if she ultimately disagreed with them. They could have helped her pick her battles more strategically. Anyways, that's interesting, right? I think it is.
It's very interesting because it's common sense. Like, seriously, every single one of those things is common sense to most of us who follow true crime and trials.
Especially
like,
pro se defendants.
Yes, exactly. Yes.
And I asked it, I was like, what is Lori Vallow's main complaint in this argument? And it says Lori Vallow Daybell's main complaints in this argument revolve around 2 interconnected issues concerning the state's alleged aggravators in her non-capital case. So she believes that she is entitled to a pretrial probable cause hearing for the specific aggravators alleged by the state. She repeatedly cites Rule 13.5, arguing that because these specific aggravators were not presented to or found by the grand jury, that they constitute an amendment or an extension to the indictment, thus entitling her to a hearing to establish probable cause for them before trial. She expresses frustration that the judge is denying her motion for such a hearing. It says she doesn't understand the purpose or necessity of a separate aggravation phase after a potential guilty verdict, especially if the sentence for the charge is fixed and the crime is already considered quote unquote dangerous. She questions what this phase achieves if it can't alter her sentence. Quote, you can't give me less time. You can't give me more time. What is the purpose of how does it change anything after that? Unquote. She sees it as an unnecessary additional proceeding, particularly if the jury has already made findings related to the dangerousness of the offense during this guilt phase, though the judge clarifies the dangerousness finding is separate. So in essence, Lori feels the process is procedurally unfair because she's being denied a preliminary review of the aggravators, and she views the subsequent aggravation phase as redundant and without a clear impact on her potential sentence for this specific charge. That's fascinating. That's her main argument.
Oh, gosh.
That's not even the one I asked about the narcissism. So that'll be later.
She can't even outthink AI. And
no.
No.
It's even saying circular arguments. It's saying redundancy. It's saying she doesn't grasp, what rule, whatever it is even saying. So yeah, she fixates on irrelevancies. Yeah.
Yes.
I wish it was better to hear. I wish it was louder. I don't know why the hell they do that.
Wait, How did we go? We lost that. We lost that. How did we lost that?
I have it if you don't.
Here we go. I got it.
Oh, Northwest says play video. It gets so much better. Okay.
All right.
Nope, you're just playing our video. You're playing
Right?
this.
Right? That's, hey, I'm okay with that. I'm okay with that.
Sure. Make sure you like, subscribe, share. I'm
This
just being silly.
probably is the right one.
Yeah.
The dangerous.
There's a dark ear.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well, we
there's
use-
one sentence, there's no arguing the sentence, and if it's already a
She just tried to talk over him again.
She has the same cadence too. Do you notice like
Yes. Oh
like
my
the same
God.
cadences when she argues, like when saying that, and this goes back to Charles, when she was talking to police saying that his truck would be gone, his money would be gone, all the things, his clothes would be gone. I mean, she just kind of keeps the same argument or the same cadence whenever she's pointing things out or trying to make her point.
Yes. I raised 4 boys, and she makes me glad that I didn't have any daughters, because I can just hear this coming at me as a father who won't give her what she wants.
Right.
Like, that's what I hear.
My mom would shut me down and say, well, I'm not Missy or Terry's mom. I'm your mom. And I'd just be like, damn.
You got me.
crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand. What you're saying.
There's one sentence for
Oh,
the charge. There's only one sentence for this charge.
I wonder if they're ever
And
embarrassed.
if it's already classified as a dangerous charge, is what you're telling me, right? Because it's conspiracy to commit first-degree murder. That's a dangerous charge. The jury has already found that it's a dangerous charge. Then what
Deadly.
is the aggravator phase finding?
Do you
It's
suck?
already a dangerous charge, and there's only one sentence.
Okay.
does the state want to respond why the state wants to proceed with aggravators?
Start with the
Her
jury is
looks.
not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and
Oh
or
my
the
gosh,
intentional infliction
do you
of
see
or
that?
threatened infliction.
She's
Well, I know I was typing. Go ahead.
she's sitting there with her hands clasped. She's like this, and she's
Right.
and her eyelids are closed, and she's like, "Oh Lord, save
She's
me from this
dissociating.
lady."
She's
She is.
dissociating. I don't blame her. I cannot wait to hear her. I hope she talks after this. I hope.
Oh my
And
gosh.
pray.
Oh my God. Yes, I
Look,
do.
her eyes are closed.
Do you
That's
see that?
awful.
Do you see
Yeah,
that?
I don't blame her.
She's like stressed, clasping her hands, and
Uh-huh.
her eyelids are closed, and she's like, "Lord, please save me from this lady." Like
Please,
Friday
baby
the
Jesus.
13th is the
Yes.
last day. Yes, right.
I can
Sweet
put this
little
woman
8-pound
in a
baby.
path. Yeah, definitely.
Include the use
Mm-mm.
of a weapon and or the intentional infliction of or threatened
Oh.
infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense?
He's deflecting it back onto the state.
Your Honor,
Yep,
in all honesty,
100%.
you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already
Oh.
going to have an aggravation phase
There
for
you
the
go.
dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
Yeah.
Was it not already found to be
Did you see that?
Just said that-
She
Yeah.
like, she made her little argument, and then she like pushes back in her chair, and she's like, "Mic drop."
Done.
That's
It's
yeah,
it's like, yeah.
that's her mic drop moment.
Absolutely.
I love it. I love it. I like her a lot. I do.
Going to have an aggravation phase for the dangerous allegation to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
Mic drop. Boom.
How is
Yeah.
it not already found to be dangerous? You just
Shut
said
up.
that if they find me guilty, then it will be dangerous.
When?
I did say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now,
What
think
did
I
she
meant
just
was
say? That it will be what? Oh my God.
Yeah.
She is doing a circular argument. Like, and I
Yeah,
don't blame him
totally.
for delegating that out to the state. Like, come on, help me. I don't want to fight this one. Kinda,
Then it will
I
be
don't know.
dangerous.
I did say that.
Let's
I
go
said
back
if they find
another
you
like
guilty-
30 seconds. There
How
we
is
go.
it not already found to be dangerous? You just said that if they find me guilty,
What?
then it will be dangerous.
I
No,
did say that. I
it's
said
dangerous
if
the
they
whole
find
time.
you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was
I think what I meant was, Judge Pereski, you got to do better, dude.
He might be dissociating too. I mean,
He probably is. He's thinking about his convertible. He's
yeah,
thinking tomorrow
after
jury
work.
selection. Yes. He's thinking about
Yeah.
like there's a 2-finger bourbon sitting waiting for him in
Right?
a cave at home.
It is a tactic, golden rule. It's her MO. Like, this is what she does. Obviously. And I never would have known this because I've
She
never seen this
convolutes
side of Lori.
everything. She convolutes everything, right?
Yeah. And I mean, I
That's-
can't imagine being married to her. I can't imagine being one of her children. I can't imagine being one of her freaking siblings, but I mean, I'm just saying they kind of come from the same pool.
And there are 3 dudes who can't imagine being married to her right now too, because they no
2 are
longer
dead.
are.
2 are dead.
Yes.
Right.
And one's on death row.
Don't cross her, or I mean, not even that, but don't be viewed as being crossed by Lori. Right.
Ugh.
She also has an attorney from her past that died of a heart attack. Suspiciously.
What?
I say suspiciously, but yeah, there's quite a lot of people around Lori that just dropped dead.
There's a trail of bodies.
Trail of bodies in her wake, for sure. I don't think
Now,
she's done either.
I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury
Mhm.
found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's
Yeah,
something that
deadly.
You have to-
Like, what do you expect?
What? A jury
Not a water
finds
gun.
dangerous to shoot at somebody with a gun?
Yeah,
What?
I'd say they missed.
That's crazy talk.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge with one statute? You can't give me less time. You can't give me more time. You can't do anything else except for
Don't tell me I can't.
there's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has.
So
to
she ain't gotta
find
do
or
it
not
twice.
find for purposes of sentencing. And they have the right to proceed with aggravators.
And because you get off on it.
You're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing
Shut
before
up.
trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So
Oh, snap. There's a legal argument that you didn't catch. Imagine that, Miss Lawyer Lori. It was included in your charge. We're going to go back like 20 seconds just to rewatch that.
I have some really quick. It's just
Yes.
it's a funny. Okay. I think we need it.
Okay.
Okay.
We do.
Am I up there?
Hold on. Let me remove that and then add that. There we go.
Ready?
Mr. Madison, what you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it. I award you no points, and may God have mercy on your soul.
Okay, a simple wrong would have done just fine, but
It fit. Okay. It fit.
It did.
I hope it made everybody laugh. And we just have to collectively not be dumber. That's all.
Right. We try not to be dumber for it, but you
Right.
know,
She has this effect. It's like, what are we even talking about?
It's included in your indictment. So
She would have argued.
We didn't find these specific aggravators being a dangerous offense, and these
Can
specific
I finish
aggravators
what I
are
said, what I
different,
was saying?
right?
I didn't interrupt you. Can I finish?
what?
Exactly. Slap the shit
Oh
out
my-
of her. I'm just saying. Zap.
That's a narcissist trait, though, right? Like I can even interrupt a judge. It's
Yeah.
like I have every right to
Zero
interrupt.
effect. She says that
Yes.
about zero effects, and we see it so many times.
Yeah.
That was
A
today.
dangerous offense,
Yes.
and these
Can
specific
I finish
aggravators
what I
are
said, what I
different,
was saying?
right?
I didn't interrupt you. Can I finish? Okay.
I didn't interrupt you. He
Right?
gets a little testy from time to time.
I-
Like I think that's the third
Rightfully
time I've seen
so.
him. Yes.
Yeah.
Absolutely. Like it's 3 times and it should have been 30.
Or none.
He's-
You know,
right. He's
if
so
you had
patient.
respect for him. Yeah. Yes.
Right.
The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
Correct.
When
Correct.
someone says they're going to choke someone to death and they don't actually
Oh.
do it, it's not a
What?
dangerous crime.
So
No dangerous instrument or
I have to
deadly
think about
weapon
that.
was used.
Yeah, me too.
because some instrument may or may not have been used in this crime, it's considered a dangerous crime.
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime.
Correct.
It's a gun.
And that is supported by case law.
Yes.
So that what? When you go to appeal,
And she goes, and that's supported by case law.
Yeah.
And judge is like, no, it's not supported by case law. I'm just like pulling it out of my butt.
My arse.
Oh, for crying out loud! This is.
I wonder if they're
unreal.
embarrassed at times. I would be like, oh my God, secondhand
Well,
embarrassment.
look at Pam and is it
Yeah.
John Abernathy? Is his name
Abernathy.
John?
We'll just call him
And-
Abernathy. Because I don't
All
know.
right. Hicks and
But-
Abernathy are sitting there looking down, studiously looking down like we had nothing to do with what she's saying right now, with what she's
Yeah.
arguing. Like we gave her some advice and she just
Mhm.
like took it to a whole nother
Runs.
level.
She
Yeah.
makes it whatever.
That's right.
It's like she hears things so differently.
Oh, she does. She does.
I was watching a
absolutely
panel on Justin Lum, Fox 10 Phoenix, about the first hearing, and Rachel, one of the prosecutors, special prosecutor, I think she was special prosecutor, in the case in Idaho, she was like, she's just kind of, I forgot, I forgot what I was gonna say, but it's interesting what they said too afterwards, or during, just commenting on it. Oh, like even it was amendment. I'm sorry. Is it amendment 6? Wait, what did she say? He's violating her 6th and 14th amendment.
Yes.
rights or something. And she's like, fundamentally, Lori misunderstands that. And then, so it's like, and even Rich Robertson, who was the private investigator for Brandon Boudreaux and my parents eventually, he kind of says the same thing. It's like, he said, it's a lot of what militias tend to use. I think like mafia type people, they've heard it before and they just try to stick it into an argument. And then they think they have some kind of merit based on that. And it's not.
Yeah, it's not.
Yeah.
Hey, we have a guest that we can pull up here with us.
Who? Megan. What's up, girl?
Megan. What's up, Megan?
Unmute. You're muted. Unmute yourself.
Come on up.
Just yet.
No.
Maybe
Right?
not.
Maybe
now or forever hold your peace. Come on, girl. Yeah.
Forever hold your peas.
Your peas or your peace. Both of them.
Yes. I don't like peas unless
I
they're
love
like
peas.
fresh garden spring peas. I love those.
Had some last night. They weren't out my garden, but you wouldn't have liked them.
All right. We're going to keep watching this and I'm going to go take a break while we watch it. So if anything really, really fun happens, I'll rewind. I promise.
Okay. Allegedly. I'm going to go off camera too because I'm smoking. So I'm still here though.
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them.
Complicate.
So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
Where did Megan go?
These specific aggravators that they allege, right? The ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in. And what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So, do you have other issues that you want to bring up today?
I do too. I think she has MPD too.
I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators.
Correct.
You're dark.
Before trial starts.
Because you're not entitled to one.
Yeah.
Okay.
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference
It's
between...
an extension of the indictment. It's not in the indictment.
It's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These aggravators,
that's exactly my point.
This is why we don't do it with jury.
These aggravators, if they are found, what do they do to change the charge or change the sentence or change anything?
Probably nothing in reality. You just said it.
Let's go back and listen to that one more time.
Probably nothing in reality. Yeah.
That's cray.
Girl, let go of that tissue.
You can
How are you entitled to that and I'm not starts?
because you're not entitled to it. Explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my...
Yes,
she does all she's wanting. Like, you're denying this too. I'm keeping a tab, basically. Kind of what it sounds like.
Like,
right?
is he more than 50% dark right now?
Oh,
And you're
he's under the dark house.
And Megan, you're muted. Just so you know, you're on stage, but you're muted, girl.
Yes, I'm here. I am
Okay.
driving, so I'm going to keep my camera off and I'm going to keep myself muted until I have something snarky to say.
Okay.
Is this a hearing from today?
Yes.
The other one, there's
Okay.
two.
Okay, gotcha. I only saw the one where the
With
other
the
judge, Judge Green, denied
yeah.
her motion to have Judge Bereski removed.
Me
So,
too. This is the first time I'm seeing this one, so
yeah, nice.
yeah. Bring your snark.
Yep. There's all kinds of snark available on this one.
Yeah.
The snark window is open.
Always. That just pissed her off. Heather Rose says.
Motion to have a hearing on this?
I'm
Her
denying
chicken
your
head.
motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct.
before trial starts.
Because you're not entitled to one.
He just told her that she's not entitled to something.
You're not entitled, Lori.
Right.
Oh my gosh.
And she's like, what? Oh, yes, I am. You know, she thinks she is.
Wow. He just literally told her she's not entitled to something.
Good.
I cannot
Are we-
imagine what. Go ahead.
Are we going to get another motion to dismiss based on this denial?
Are you a fortune teller? A seer?
think-
A revelator?
We need to have some kind of a drinking game about her
We do.
motions to dismiss.
We do.
Did
I
you
will
guys already
ask
come
her.
up with it?
We need to. No, well, not specifically, but yes, we do. We do.
I'm working on my new bingo card for this trial. So
Yeah. Well, you include some really outlandish things that no one could think of but Lori. You tried
well,
to.
the thing is, like, I thought I was being pretty outlandish last time, and I think I filled my bingo card on the first freaking day.
Yep.
I
Maybe
believe
day
it.
2.
I believe it. I think, yeah, I definitely want a bingo card for sure.
Well, I put
Mhm.
it on my Patreon last time, but this time I'll just share it with everybody. We should all enjoy the fun.
Yeah, and like somebody said, we'll be too drunk. Well, we're gonna be drunk. Just know that. So make sure you do it responsibly and all the things. But yeah. Oh my God.
You're not entitled to. Yeah, he literally
Yeah.
just told her you're not entitled, but she
Just
thinks
took her
she
wand
is.
away.
Yes, right. Oh my gosh.
Yeah, Ruby.
I also really liked it when he said, I'm not going to explain it to you.
Good. Right.
He doesn't
shouldn't
need
have
to. It's
not his
that's not
job.
his job. Yeah.
Mm-mm. I think I think probably what you're saying is like he did that way too much in the other one. And that's where she didn't even notice, like that flew right over her head because she already thought that he was being biased against her. She said it earlier.
Right. She already thought she was entitled to whatever
Yeah.
he was giving to her, granting her, helping her with. Like she deserves that. Like,
Mhm.
but not now.
Megan, before, I don't know if you were here earlier, if you were listening, but I ran this transcript through my AI chat GPT and asked it to, based on this transcript, where did I put it? It's right here. I went to the wrong thing. Hold on. Back to the other where I started. So like, based on this transcript, point out any narcissistic tendency Lori Vallow Daybell may have. And so it listed a gamut of things. So we'll have fun with that.
That's like a whole other broadcast. Yeah. That's like
a whole other bingo card, a whole other drinking game.
When AI can find it, we all see it.
Yep.
We do. All right, where did we go? Here we are. Play.
You're entitled to a probable cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference
It's an
between-
extension of the indictment. It's not in the indictment.
It's a difference
Oh my God.
between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment.
Oh, what we doing
For
with the camera?
example, if you
Right? What was that? That was weird.
It's like it was walking over.
Yeah, I know right where that camera goes in that courtroom, and that was
It's going
that
down the
was
damn hallway. It looks like. Is that a hallway?
if you were just charged,
that's
Or
the it's
partition
a
or
little
something?
yeah, it is. It's a little hallway that goes back to the room where she sits until she comes out.
Go there, Lori. Go there.
Okay, so this is I don't really mean this to be snarky. I'm being sincere when I say this. That Lori, I mean, we know she has a gap in her understanding of legal procedure and legal definitions and things like that, but I also think she just has a gap in her understanding of basic vocabulary, you know? An amendment means that you're adding something to it, and that's not the same thing as changing it. So I just think that there's like a cognitive lag there somewhere where she's really just not putting two and two together.
And it's like she's so with the semantics of things that kind of gets her stuck on one idea or something.
Well, yeah, and that's another trait of people with personality disorders is that once they have a concept formed in their mind, they're so rigid that they can't really change it or see any nuance in an argument.
That tracks. That's why no one was murdered in this case, the kid's case,
Yeah.
But Tammy, too. Yep. I hear me talking in the background. Joe, you might want to close that window. I don't know.
to commit first-degree murder, all right, but the state didn't allege with
It's
the
like
grand
a
jury that
echo.
it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
That's
aggravators,
exactly my point.
Oh my God.
After the fact, these aggravators, if they are found, what do they do to change the charge or change the sentence or change anything?
probably nothing.
Oh my
in reality.
God.
You just said it. They don't.
Nothing in reality.
Probable cause hearing.
Oh my
Then I
God.
don't want to have an aggravation phase either.
Well, you can.
Oh,
Are
when?
you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend.
Oh. Yes.
He's done with her.
I can't
He
wait
is-
for the trial.
He is 100% done with her. Like
Yeah.
I have never heard him talk to her this way before, ever.
And
I'm
justified,
honestly
I
glad.
think.
I'm honestly
Yeah.
glad because I think he was very lenient with her during the last trial. And I think it was an abundance of caution to prevent any appeal issues. And he
Trying
was so
to
patient
appease
with
her.
her. But
Yeah.
now she's had an entire trial. She's had all this experience now with this judge in this courtroom. And I think he's at the point now where he's like, all right, I'm going to ratchet this down. And I'm glad he's doing it.
Yes. He overabundantly accommodated her. And it's good to see him not lending himself out for that this time.
Yeah,
For sure.
because I mean, here's the thing we need to understand is that when you do that with a person with narcissistic traits, when you are accommodating to them, they see it as a weakness. And I saw so many times during the last trial, Lori trying to exploit the judge's kindness.
As a
And-
weakness. Yep.
Right. And he didn't allow her to, but the fact that he opened the door in the first place, like sort of lets her get her foot in.
Yes.
And I don't think
She thinks he's entitled.
yeah,
it.
and I don't think he did it on purpose. I don't think he was trying to, have a weakness for Lori, if you want to put it that way. Again, I just really do think it was an overabundance of caution. But I'm glad to see now that he's like, okay, now this defendant has a record of acting this way, and he can be a little tougher on her without risking an appeal issue.
Yep. I agree with that. I'm glad to see it too.
Yeah, and his patience can run its course without legal repercussions. Like
Or bias. Right.
Exactly. Yes. As a judge, you have to be very aware of any biases, and we're past that now. I think that's what it looks
And
like
I'm
to me.
glad. It's like we're
Yes.
going to see a whole different trial, I think, this time because of that.
I agree.
It's gonna be, yeah. It's going to be done by Friday the 13th at the latest.
That's going to be weird if it lands on Friday the 13th. I'm just saying.
Yep.
Whew.
What else?
Her and her damn
What else?
glasses.
What else you got for me?
With your
Something
ponytail
going on with the
ring.
trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there
How many
some
people
way
you
we can do
need?
that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
Right, because you sit them in the back.
Whoa, whoa! Watch Abernathy's head after she asked for this. Watch his head. That
Is it on
cracks
a
me up.
swivel?
Like,
Is it on a
what's
swivel?
It is. I'm like, what the
Mm.
hell is going on? She's asking for more headsets during the sidebar. So the sidebar is white noise with electronic headsets where they can all talk on the headsets, and the gallery is supposed to be subject to the white noise so they can't
To-
hear what's going on.
To
under the-
accommodate her from having to walk up there.
No, it's a court thing. It's not a Lori thing.
I
It's a
thought it was
court
to accommodate her.
No, it's a court thing.
Hmm.
It's a new court thing. White noise is like
like
the
it.
thing. In
Well, I
court.
like the white noise, period. But I mean, unless it's too loud, but I
Yeah.
liked it in Idaho. But I mean,
But
the headset thing is new to me, and it is interesting. It
It's
cuts
new
down
to
a
this
lot of
court
that.
too. It's new to this court too. Like her last trial was
Mhm.
was an experimental phase of it, and
Yeah.
they got it to work for the most part. There was one time when they didn't, and so she had to go up there for an actual sidebar, for like a physical sidebar up at the judge's bench.
I bet hers felt so special.
But watch Abernathy's head in this.
I want to play it.
For headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets.
Watch his head. Here it
Is
goes.
there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
Here it goes. Bop, 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 bop. He just like shook his head back and
Like you had a chill.
right.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and there's
they
no
can't
more
do-
available headsets?
They can't
Oh my
do
God.
more than 5 on that particular
System.
or network that they have. I need my court reporter to have one so we can do the sidebars.
Should we see her computer?
Can I ask a dumb question?
Go for it. She does.
It won't be dumber than Lori's question, I
Good.
promise.
We don't think so.
So she's got 2 advisory council. She's got her investigator. She's got her paralegal, and then there's
Mhm.
her. That's 5. Does she
5.
need more than that?
5 is total for the entire court. So
Okay.
judge needs
Oh.
one, prosecutor needs
prosecution.
one, and
Yeah.
she gets 3.
So already she's being, again, over accommodated because judge gets 1, court reporter gets 1, defense team gets 1, and she's
Okay.
asking for 3
Additional.
for her side.
Yes.
I don't, and I guess so. At least one of her advisory council can have one.
Yeah, exactly. So judge, court reporter, Trina K, Lori, and one of her
Yeah.
advisory council. That should be more than enough.
Yeah, maybe give them one instead of giving it to your paralegal who sits next to you. I don't know. She is something else, y'all. She is something
But
else.
she brought this up during the last trial too, or at the beginning of the last trial. She asked for
Yes,
more
she did.
headsets. And the
Yes.
judge told her the same thing. It's like we haven't changed. We're going to be in the same courtroom with the same capabilities.
But she just asked him, you said you were going to check on that. Have you? Like kind of calling him
Yeah, like
out,
trying to call him a liar. Did you actually check on it, or did you just tell me you checked on it?
trying to put him on the spot. Yeah.
Yeah.
Trying to catch him. Wow. Mm.
Have beside yourself, you can choose one of your advisory council or your paralegal.
You're forcing
If
me
you
to
Right.
choose.
He just said you can
you
choose either your paralegal or your advisory counsel.
Yup.
And she's like, no, I want both. And he's like, no, you can't have both. And she's like, but Mom, I want to go out with my friends on Saturday night.
Dad said, yeah. Mm-hmm.
Exactly. Yes. This is like her playing dad versus mom. Like I could not imagine being one of her parents, either one.
Well,
I
I
have
kind of
no
think that's
opinions.
why we
Yeah.
see the Lori we have is because it's a learned behavior.
That was rewarded, right?
Oh yeah, over and over and over again. She was, I believe, she helped accommodate them cushy lifestyles because Charles paid for things.
Well, all I'm going to say is that in a family system where there is a narcissist or someone with narcissistic traits at the head of the system, oftentimes children will become exactly like that parent as a protective mechanism. And the parent who sees the child modeling their behaviors is proud of it. And that's what makes a golden child a golden child.
There you go. And so it was probably Barry, I think, if I had to speculate.
Allegedly.
You said the quiet part out loud.
In my opinion.
You said the quiet part out loud. But
Megan did. Megan blew that out the water. She pulled it all together for us. All the things that we suspected for sure. All the things I did. And she put them into a nice, pretty little box and a bow on the top and was like, here you go. You don't have to slam them. You don't have to say anything rude. You just point out their own behavior.
Pandora's box.
Thank you for that.
Yep.
Between the people that are helping me?
Sure.
Okay.
Technically, I don't know.
You
represent yourself.
You're forcing me. She just said, I can't resist the urge to stop. You're choosing me to force between the people that are helping me. She just said that. Like, Megan,
okay, do you remember her trying to bring this up in her opening statement during the last trial when she said something about forcing to choose between protecting someone you love, and Trina K cut her the hell off?
Good point. Good point. She's forcing her to choose. Nobody put her here but herself. Like she wouldn't be here if she had not.
No, Kresha, I think you'll find that Lori's being forced to do a lot of things.
I don't think so. I don't think so, girl.
According to her.
Right. My God.
This is just
it must be so confusing to be inside her mind.
I don't want to go there. I don't.
Right. You won't come
Listen,
out. Like
this
the
is
Hotel
what
California.
happens when you delude yourself into believing something that's not true. It requires so much mental gymnastics that it's like going through a freaking obstacle course every time you have to make a statement or an argument. You know, you're like, I can't accept the reality and the truth of this thing. So therefore, I have to go 10 miles this way and 16 miles that way, and then into the third circle of hell before I actually understand what I need to say.
Because it's not true. It's
right.
You have to go through all the lies. And so who says, I forget who just said this, but asked if, Gritty Gret asked, was Janice a subservient wife to Barry? I think it's a relevant question. As far as you're aware.
I don't know if subservient is the right word that I would use, because I do think that Janice does have her way of being assertive. And I do think that she's smart. And I don't think that she just blindly did whatever Barry wanted her to do. At the same time, though, I think she was an enabler. I think there was a level of, this is too hard for me to fight against, and I'm just going to accept it on so many different things.
Kind of like a sneaky, like if Barry put his foot down, would she go around that maybe?
No, I wouldn't say that she was sneaky. I think that she honestly, I think she did stand up to Barry, but I don't think any amount of anything that she said was going to have an impact on his behavior, his actions. So, and I'm totally speculating here because, this next part that I'm going to say, because I wasn't there, but based on the stories that my parents have told me about them and my parents too, when they were all young and newly married, there was a level of control being exerted by the men over the women that would have worn you out really fast. It would have been
Wow.
really hard to keep fighting against that over and over and over. And I
Wow.
understand, like, as a Mormon woman being raised to be subservient to your husband, or it really was like, you support your husband no matter what.
Who is basically the gatekeeper to your salvation in
Yeah,
Mormon heaven,
you can't get into heaven without a husband. And so,
calling your name.
right. And
Right.
so you have to support your husband even when he's wrong.
That's crazy.
And it's like you really can't do anything. Like, you're really stuck in that situation because
That's really that's tragic.
yeah, I mean, like, let's say that your husband is doing something really, really wrong. Like, maybe think about the worst thing that you can imagine a person
Okay.
doing. Imagine if your husband is doing that worst thing and you
Oh,
call him out on it and he says, "No, I'm not doing that." Well, what do you do at that point? You can go to the
that
bishop
makes
and be like, "Hey, my husband's doing this thing, but he says he's not doing it." Well, what's the bishop going to do?
right.
Call him in,
That
have a
makes me
talk with
think
him. He's going
about,
to say, "I'm not doing it."
yeah.
Where's your power
That
in that? You have no power.
that makes, like you saying that makes me think about Melanie Boudreaux Pulowski accusing Brandon of looking at corn,
Hmm.
and his whole family being the Gadiantons, basically. That makes me question that. Like, I don't know. But so, I mean, is one of her reasons for doing that because her salvation was on the line? Like, I don't know. I'm trying to get in their heads and it's impossible.
Yeah, I mean, we're never going to be able to understand it from a rational point of view. But if you think of it from a delusional point of view, then you can kind of sort of start to understand it. I know that sounds weird to say, but like
No.
that's how I'm able to understand the argument that Lori's making, is because if you look at everything through the lens of, I'm a victim, everyone's against me, and I deserve this. If you look
Persecution.
at it through that lens, it's easy to understand what argument she's
Yeah.
trying to make.
Yep. That's true. Oh, Lori.
Oh,
Lori.
Lori.
Named Lori after her sister was named Laura. That's also fascinating to me. Yeah, I'm just like,
Wait,
not
what?
very
Even
separated.
from a young child, I never understood that. So Joe Schmo, do you know about baby Lolly?
I do not.
Okay, so in the Cox family, there are 6 children. Stacy's the oldest, then Alex, then Adam. Then after Adam, there was a baby born whose name was Laura Lee, and they called her baby Lolly. And she had a congenital heart defect and died at the age of 6 weeks. 1
Which
year and 4 months later, Lori was born.
Laura, Lori. It just is not
It's very odd.
and it's also odd that, like, when Adam went up and testified in Lori's last trial, and he's asked to name siblings, right? And he leaves out, wait, no, did he? He did include Stacy, but he did not include Lolly, which is the inspiration for Lori's Lolly time at iCloud.com.
Right, but I
Right.
can also understand if you had a sibling die, and Adam was barely 2 years old when Lolly
Mhm.
died,
I
so he
asked my
wouldn't
mom the
have
same thing.
remembered her, and some families, especially back then, didn't really acknowledge a child, like after the death of the child. I know there are
Right.
lots of people now who will have a funeral for a miscarried baby. People
Yeah.
didn't do that back then. And while
Mm-mm.
Lolly was 6 weeks old and she does have a grave, she does have a headstone and everything like that, I can understand from Adam's point of view, not really
Right.
counting Lolly because he never remembered her. And,
I asked this
you
of
know,
my mom too, because when my mom testified, she left out Nancy,
mm,
which she was born between right after my mom, but before, I think. I gotta think of, yeah, my mom was already alive. So she was born after my mom, but my mom was little baby, a toddler, and my Uncle Bobby, who's the last one. So I was like, why'd you do that? And she's like, I don't know. Like, it didn't even cross her mind. And And I guess it's because, like you said, it just wasn't really a big thing back then. And I mean, they didn't grow up with Nancy because she died when she was 18 months old. So kind of the same. I just am trying to understand, like why.
We're all
The
trying
why.
to understand.
Yeah. Even generationally.
Yep.
But yeah, that is Lori and Laura are just right there in the same category.
It's so crazy. So
Found
crazy.
it interesting.
Yeah. All right. Let's keep going with the hearing. We're almost done. We haven't even gotten to the documents yet. So we
Right.
have filings that came down today.
Your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not.
We don't see it though.
Thing because you are acting as your own attorney. You're expected to proceed as
Joe.
your own attorney.
Yes. What? You don't?
It's not on the screen. Right.
What? Oh my
What?
gosh. Oh my gosh, that's crazy.
I can actually hear it better without looking at it.
Right?
I think
I'm
a
gonna have to
portal got
stop
me,
it
but I'm back.
And damn portal.
restart it.
The portal will always be the fall guy. The fall guy.
All right, we're going to go backwards a minute or so, then we'll start up again.
Okay, thank you.
Once again, it's the judge telling Lori she can't have what she wants. And how does she
Bring
react?
it.
Have beside yourself, you can choose one of your advisory counsel or your paralegal.
You're forcing me to choose between the people that are helping.
Sure.
Okay.
Technically, I don't know. I even have to.
He says that so casually that cracks me up. He's done with her. Like, he is 100% done with her. She says, you're forcing me to choose between the people that are helping me. And he says, sure.
Do you remember Nancy Joe doing the same thing? Lori would
Yes.
mischaracterize a statement and Nancy Joe would go, sure.
Yep.
It's such a perfect comeback because there's no way to argue with that word.
Sure.
Sure.
You're forcing me to choose.
If
Sure.
that's the way you see it, fine, whatever. It's kind of like whatever. It's a little more respectful than whatever.
To the point too.
Whatever.
You don't have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing because you are acting as your own attorney. You're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory counsel.
Oh my gosh. Oh, they don't even have the obligation to provide you with advisory counsel. They are her advisory counsel, but they don't have to do it if they don't want to. And I'm just going to throw this out there. This is pure speculation, but I would bet that Pamela Hicks does not want to give her advisory counsel. I've seen Pamela Hicks in person, and she just looks like she hates every day that she has to come into court with Lori.
I don't blame her.
Every day of it. Like there was a day when the public was standing outside. So the public seating area was right next to the defense counsel's waiting or break room or whatever you call it. And we were all standing out there. And then everybody stands up when it's like 5 to 10 minutes before we go into court because nobody wants to miss their seat. And she was coming through, and I saw her coming through from like 15 feet away from the elevators. And so I turned around and I told everybody, all right, make room for Pam Hicks to come through because she's got to go back to that door that's next to our seating area. And she acknowledged that. She said, thank you for that. And I was like, that's the only day that I ever saw her like not hating her life representing Lori Vallow Daybell. Like, she looks like she hates it every day.
When I was a freshman in high school and I was in band, played the saxophone, and I also eventually started doing color guard, but we did The Wizard of Oz. And there's this one section, I still can't get it out of my head, but that's what I would play. When you were just saying that, I was like, dun 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 dun. Just like when the Wicked Witch was coming. That's what played through my head, if anybody wanted to know.
I like Pam Hicks. Yeah, I like her, but she has
she's
a really tough job. She has a tough job.
I mean, she was awarded this, like it fell in her lap, and then still appointed as advisory counsel for Lori during these hearings. So
and then Lori said, "I don't want you. I'm going to represent myself." And Pam was like, "All right." And then Lori said, "You can't even sit at my desk, at my table
behind me."
Yes, you're relegated to sit in a chair behind
me. Had to choose. She had to choose, Joe. like Megan said. Yeah. I want a black background like you, so you have to tell me how you did it in a little bit. Besides turning all my lights off.
Probably helpful to you. Okay, but you chose to represent yourself. It means you are supposed to act as your own lawyer.
It's not on the screen again.
You
what?
I'm sorry to point out all the things.
Oh, for crying out loud.
Damn, blame it on StreamYard. Blame it on Lori. She blames it on you, no, I'm sure.
It's totally StreamYard. It's totally StreamYard.
They need hazard pay, Jermaine says. Agree.
All right. Are we up there now?
Yep.
Okay. Yeah, I did. In case you decided not to represent yourself so they could step in at trial.
Okay. Well, then is an alternative that we could do sidebars at the bench so that they could be involved in that time.
It depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue
she don't do good with that.
Everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay.
Again, that's an over accommodation by the judge. He doesn't have to allow her to approach the bench, especially in her prison, jail, incarcerated situation.
No, correct. She actually cannot be anywhere but at her desk where she is now and at the podium. Like he literally, that's a court order that she can't be anywhere but those two places. But
the same for the prosecution, because one can't go and utilize everything to the full extent as a prosecutor because then it would make she's only able to go to these certain areas, I guess. So as to not be unfair, I guess, right?
Right. That's why Trina K. No, you're right. Trina K had to have her paralegal deliver things to the witnesses.
Right.
And Lori had to have her paralegal deliver things to the witnesses.
So that it wouldn't appear unfair or unequal.
She can't appear different, or unequal to the prosecutor. And I remember in the last trial, there was a point at which the headsets didn't work. And in that case, they had to send the jury out so that they could do the sidebar in the main courtroom, just openly, audibly to everyone.
Can you imagine if they had to do that every time?
Oh, man, I got so annoyed with John Pryor's sidebars, and I was afraid that it was going to be like that with Lori too, but it wasn't that bad, to be honest.
Right.
Judge Boreski did deny her a sidebar at one point. I always think that's great.
Oh my God.
Yeah.
Oh my God. Yeah, that had to be awesome to see. It's so much easier doing it from your home, from the comfort of your home, though. I think you made a good choice.
I tell you, I was drained after I finished my second live today. I mean, obviously I chose to do 2 lives today, but I think the drainage for me is having to be inside of Lori's head for that whole time. And, reading through and analyzing everything. Plus, I don't know, it's just been an emotional day for me. I had anxiety about today anyway. and I had like an anxiety dream with Lori in it last night.
Yeah. Yeah. I heard you say that earlier.
Which
Oh,
one
God.
of the funny part was that we were at some kind of a party, and she said, "Those kind of clothes look terrible on you."
Just know she's projecting, even in your
Yeah.
dream, girl.
Yeah. But there was, I mean, but it was also, there was also like an emotional aspect to it. Like, you know, Tylee was in my dream and stuff like that too. So it's
Mm,
like, obviously have some emotions still to unpack. And also, you know, I
yeah.
get caught up at it unexpected times. Like when I was reading through that, the incident at the hotel with Tammy Lachcik, you know, when she
Mm,
basically said to this female officer, I felt like the male officer was shaming me, and I'm just asking for help. And it just made me, it made me think of Charles, you know, it made me so
yeah.
sad. So anyway, it is draining, but you're right. At least I am at home and I have my people with me.
Yeah. And it's just the comforts of home. I'm telling you, it's not only financially draining, it's draining emotionally too. I mean, they're both the same in my opinion, you know.
Yeah.
I
And
mean,
I'm just remembering my creepy apartment where I couldn't sleep too. You know, at least
oh
I'm in
yeah.
my own bed at night, you know?
Yeah. Oh yeah, you did have a creepy apartment, huh? Your
Yeah.
your bed and
Well,
breakfast or something.
Yeah. The
B&B.
Airbnb.
you also stayed with Lori for a little bit, right?
Oh, that's yeah. In her past.
What do you mean?
We were just
You
talking about the
lived
creepy apartment, but that's
no, no,
Oh,
while you were at the trial.
oh, yeah. I thought you meant while I was at the trial. I was like, what?
no,
No.
no, 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 no.
Yeah.
Before you lived with Lori for a very brief period of time, right?
Yeah. When Lori was 19 and I was 18, and Adam was a DJ in Austin, I lived in an apartment with Lori and Adam for about 4 months.
Hmm. I'm sorry.
It was stressful. It was really stressful. And looking
Walking
back
on
on it
eggshells.
now, yes, walking on eggshells. And it just reminded me that, you know, how much I changed myself to
Hmm.
fit into what Lori wanted so that I didn't upset her because I didn't want to deal with this,
Think
you
about
know.
how the judge is kind of doing the same thing,
Hmm.
or did for sure in the last
Did, yeah,
trial,
did for sure in the last one. I don't think he's going to do it anymore.
right? Yeah,
Yeah.
it's
He's running
interesting.
out of out of that I'm living
And
with in
ideas.
Lori's world. Yeah, right. All right,
Mm.
here we go. More video.
Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can
Oh, wouldn't you
prepare my
like to know?
questions without being accused by you of opening the door? How can we avoid
What?
that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will
Shut up.
tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings.
To not open the
State
door.
agrees,
Yeah.
right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or prior proceeding, that maybe we should take a break.
Okay.
I love this judge. Like, I love him because he is bringing in this legal information and the legal rulings based on law that
Yeah.
he knows off the top of his head. Like, he's not going and saying, I need to study overnight. He's like, I know the law off the top of my head, and I'm telling you the law off the top of my head. So we're just going to tell the witnesses that they can't bring in, stuff from prior acts. And it's all good. It's all good.
He
I love
basically
that
said that.
too.
Oh, go ahead.
Well, I was just gonna say, it's really as simple as, Lori, if you don't want the door open, then don't open the damn door. That's really what
Very easy.
all that needs.
Yep.
Right. There's always a chance of that happening with people testifying. It kind of crept in, I want to say, in the last trial. I think it was one of the medics or the fire. I don't remember.
Yeah,
I know
one
it
of
was like,
the fire, I think it was one of the EMS guys, he was giving his qualifications. Trina K asked if he had testified in court cases before, and he just said the word Idaho. That's all he said.
Yeah.
And I've testified in Idaho. And I was like, gasp. I held my breath for a second because I was like,
Yes.
okay, there's no objection from Lori, which she probably should have objected to that.
Right.
But then the judge didn't stop anything. Nobody said anything. I was like, okay, I guess we're good.
No mind to it. Yeah. Yeah. Don't address it. Right. That's interesting too, though. Because I mean, it can happen. People aren't thinking about that, you know.
And there are crossover witnesses between the two, which is kind of what she talked about today.
Yeah.
Not successfully. Not successfully.
I wish we could hear it better, but it's just the way it is.
Yeah, the audio is really low from this Fox 10 broadcast.
Yeah.
So I turned my volume down low. So if you turn yours up, then maybe it won't be so bad.
I feel like this has been a problem with Fox 10 since the beginning. All of their hearings stuff tends to be low, but whatever, we can figure it out.
Right.
Yeah, and the last hearing on the 14th was weird too, because Court TV and Fox 10 kind of did like a collaboration type of thing, but the guy that was there to set up the tech for Court TV and Fox 10 didn't have the actual camera, so he was waiting on the camera from Fox 10, and it didn't come in until like 15 minutes before Lori's hearing was supposed to start. So he's stressing out. Vince, who's the public information officer for the courthouse, he was stressing out. Everybody's stressing out. And finally, the guy shows up with a camera, and then they couldn't get the cables figured out. I mean, it was a mess. So, yeah.
I wonder if you can ask Vince. You said he's public information for the courthouse. I wonder if you can ask him if we can obtain the front cameras, or is that a thing, or just
that's a good question.
More remote viewing. Chris is who mentioned it in a prior trial that the streaming that I was doing that day, and I was like, what? That's a thing, So just kind of ask.
Well, we saw it today in the hearing, right? In the early morning hearing.
Yeah, there's a whole. They have their own camera system.
Yes.
Mm-hmm.
Yeah. It's a good question.
So,
I will ask Vince. Vince and I are.
And
buds.
do you have to ask for them specifically? And where do we ask for that? Maybe.
Yeah.
If you can, I'll try to remind you.
I will be there tomorrow morning, bright and early.
Oh crap! Well.
Yeah. But Vince will probably be there also bright and early, so we shall have a discussion.
Okay.
Well, I love you guys, but I love my mental health more, and I'm at the end of my wick, so I am going to sign off.
All right, Megan, thank you so much for joining us.
Thanks for letting me crash. It's always good to unpack this stuff with people who know.
Get a good night's sleep. We'll be here tomorrow, the next day, and the next day.
Yep, and the next day, and the next day. All right, take care, guys.
Bye, girl.
Take care.
Bye.
All right. So the rest of this hearing, and then we have documents to look at.
All right. Anything else?
That was it.
All right.
That's it.
Everyone.
What? All right. I'm going to rewind that just for like 10 seconds, but she just has this way with
Pissing
Like,
you off?
well, with
She
no,
does it
with
to me.
with looking at and trying to manipulate people with her
Yep.
looks.
Mm-hmm.
Like, this is the same type of thing that was in Chandler when the police officer came over and asked to see her driver's license, and Tylee was there,
Mhm.
and she said, "Hey, neighbor, this is the
I have
exact
it pulled
same.
up.
Yeah.
I have that thing pulled up.
This is the
But
exact same hey neighbor behavior.
there you go.
Like, it's hey neighbor,
Hmm.
it's hey Abernathy, what do you have for me? How can you help me?"
I don't know.
All right, we'll see. everybody
Watch
next
this. Watch her interaction with the Abernathy right here.
He's like trying to go around her hair.
Right?
I bet her breath has to stink.
Okay, so
That's
I've
it.
been informed that the
There's the hey neighbor thing. Like when she
Yeah.
flipped her hair off with her right
Mhm.
hand.
stipulate
That's hey
Yeah.
neighbor. Right there.
in any
Hey,
jurisdiction,
sorry, neighbors.
we can do that. Remember last time though, we screened whatever number we had, a few of those people didn't show up even though they were informed they needed to show up. So
Thank you, Pammy.
we have 66. I think because it's a shorter trial, we don't necessarily need
Shorter.
4 alternates, but maybe we should just in case. I don't know.
Judge, I would still want 4, given that we lost
We
2 in the first 2 days.
We did.
I don't want to waive any appeal issue that it wasn't random for whatever reason. I didn't
Whatever
understand your
reason.
total reasoning, but how it's saying like the county.
Then
by
why
county or
stipulate it?
something,
Why
or
even-
section by section?
The theory is
Oh my
that there's
gosh.
One county.
maybe
Who does
certain
that?
demographics
I don't
of
understand it,
people
but I'm
that
going to agree to it.
that wouldn't respond to an email or online, or they think it's a scam, so they want to show up at the courthouse to do their jury service. Or maybe they don't have access to the internet to begin with. So the theory is that you're missing some sort of group of people that aren't responding remotely and instead would show up at.
What the hell?
What happened? What happened?
I don't know.
Hold on.
I asked you.
It ended.
And
right there?
I'm replying to Diamond Dot and doing, and they say it's louder on other channels, and I don't know why. Like, I didn't even know it existed, so it's. I wonder who else has it.
If the jury were to find you guilty
Ah.
as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreaux.
Okay, we've
You
seen
weren't
this
in
already.
Arizona.
Oh, okay.
Maybe it's because we're at the end of it.
Not bringing
So
in
this one
any
is
jurors
louder.
tomorrow. We can do that.
It is. Yes.
Remember last time though, we screened.
We're within a minute of ending though.
Whatever number we had, a few of those people didn't show up, even though they were
Okay.
informed they needed to show up. So we have 66.
Squeaky wheel.
I think because it's a shorter trial, we don't necessarily need 4.
Squeaky Will
alternates,
said the
but
feed ended.
maybe
I
we
watched
should
this on
just in
Fox 10
case.
in
I don't
Phoenix
know.
earlier. Video just
Judge,
cuts
I would
off.
still want 4, given that we lost
We
2 in the
lost-
first 2 days.
We did.
I hope that
So
don't
they're-
happen again.
No. Oh, for crying out loud, please, for the love of God, we don't need to lose 2 jurors in 2 days. And honestly, I think that's why he had more leniency with juror number 15. Honestly,
Yeah.
because
Oh, true, huh?
if they hadn't lost any jurors before that, wouldn't he just like kick him out? Just be like, juror number 15, you're on your phone in the juror box, like you're out of here, dude. Like maybe he was paranoid about that. Maybe just a thought.
Could be.
I don't want to waive any appeal issue that it wasn't random for whatever reason. I didn't understand your total reasoning,
What?
but how it's saying like the county by county or something, or
No,
section by section.
the theory is that there's
One county.
maybe certain demographics of people, and I don't know who it is, that wouldn't respond to an email or online, or they think it's a scam, so they want to show up at the courthouse.
Old people?
Or they
Are we
don't
talking
want
about-
to.
Are we talking about old people that won't respond to an email?
Hell, my grandpa knew how to email. I'm
do their jury
not email
services.
savvy.
Or maybe they don't have access to the internet to begin with. So the theory is that you're missing some sort of
What is this? This is
group
weird.
of people that aren't responding remotely and instead would show up.
All right, that's it.
Mike Petty, she was in Hawaii at the time of Stacy's death. That's the only, I believe so about Joe Ryan for sure, but Stacy, she wasn't there, like she was with, I have something in my, okay. She had Colby, and Colby, they all went to Hawaii with her parents when Stacy died. It was just Alex that was left behind. So I agree with you though. If anything, she got a hand in it for sure. I believe. I want to go dark like you did, Joe.
I didn't do
without
it
my aunt, without my aunt deeming me so. Okay, I want to go dark on my own.
I didn't do it on purpose. I swear.
Well, you're gonna have to remember how you accidentally did it.
Right. Okay. So we have the state's response, or the state's notice of missing pages. Yeah, it's not good news.
Oh,
I
wanted to go over. Well, when do you want to go over that? The narcissistic parts of that hearing we just saw. Well, we need to do this though.
No,
right.
no. We just saw the hearing, so let's do that.
Okay.
Let's.
Yeah. So I asked AI, to analyze and point out any narcissistic tendencies Lori Vallow Daybell may have shown, and so it says, based on the transcript. So I took the transcript from the video we just watched because we couldn't hear it really well, and analyzed it. And so it says here, okay, based on this transcript snippet, we can analyze certain statements and interactional patterns from Lori Vallow Daybell that may be indicative of narcissistic tendencies. It's important to preface this by stating that this is just an observation of behaviors in a specific high-stress context and not a clinical diagnosis. And I don't have those kind of letters behind my name, okay? So here are some potential indicators. It says, number one, challenging authority and rules. Lori persistently argues with the judge about the necessity and legality of an aggravation phase and her perceived right to a probable cause hearing for these aggravators. Despite the judge explaining the legal distinctions, like aggravators versus amending an indictment, the Blakely case precedent, Lori repeatedly returns to her interpretation of Rule 13.5. Then it says possible narcissistic link, difficulty accepting rules or legal interpretations that don't suit her agenda, a belief that her understanding should prevail or that the rules should bend for her specific situation. She states, quote, now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time, unquote, and continues to push this even after the judge explains why it's not applicable in the way that she thinks. Okay. Number two, sense of entitlement and expectation of special treatment. We saw that. Regarding the headsets for her advisory council, quote, I've asked several times for headsets for my advisory council. Is there some way we can do that? Unquote. When the judge explains the limitations and that she chose to represent herself, her response, quote, but you're forcing me to choose between the people that are helping me. Okay. You're forcing me to choose between the people that are helping me. Sure. Okay. Unquote. And later, quote, you appointed them and assigned them to me. I did not ask for them, unquote. Oh my God. Can be seen as deflecting responsibility for her choice to self-represent and implies the court should cater to her preferred setup beyond standard provisions. So it says possible narcissistic link. an expectation that her needs and preferences should be prioritized and accommodated, even if it means bending standard procedures or resource limitations, framing the situation as the court, quote unquote, forcing her rather than it being a consequence, that's it, of her choices and court limitations. 3, argumentative and persistent pursuit of her own agenda. Throughout the discussion on aggravators, Lori doesn't easily accept the judge's explanations, plural. She continues to press her points, quote, but these specific aggravators that they allege, right, the ones that you just went over, what? Allege, right. I don't know why it says that. Let me start again. Quote, but these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that? Unquote. Her statement, quote, okay, then I don't want to have an aggravation phase either, unquote, after being denied a probable cause hearing for aggravators sounds somewhat petulant, as if rejecting the process if it doesn't go her way. Possible narcissistic link, an unwillingness to concede a point or accept a decision that is not in her favor, a need to control the proceedings or have the final say. Number 4, focus on how things affect her personally and lack of broader perspective. Her concern about the Idaho trial testimony is framed around her risk. Quote, how can I prepare my questions without being accused by you of opening the door? I don't want to be responsible for doing that, unquote. While a legitimate concern for any defendant, the emphasis is on avoiding personal blame. Her arguments about the aggravation phase center on its utility, or lack thereof, for her sentence. Quote, you can't give me less time. You can't give me more time. What do they do to change the charge or change the sentence or change anything? Probably nothing in reality. You just said it, unquote. She seems to struggle with the prosecutor's stated reason of procedural thoroughness to prevent future appeals. And it says possible narcissistic link, difficulty seeing situations from others' perspectives, like the prosecutor's need to, quote, cover her bases, unquote, if it doesn't directly benefit her or align with her understanding of her own immediate interest. This is the last one, but yeah. It says manipulative or, quote, playing dumb, unquote, quality. Despite the judge's repeated explanations about why the grand jury finding probable cause for a, quote unquote, dangerous offense is different from finding specific aggravators, and why an aggravation phase is still legally distinct, Lori continues to ask variations of, quote, why do we need this phase if it's already found dangerous and the sentence is fixed, unquote. Possible narcissistic link. This could be a tactic to frustrate, control the dialogue, or feign misunderstanding to continue arguing her point, rather than a genuine inability to grasp the legal concepts after multiple explanations. So it concludes with this. It says it's important to note that a person representing themselves pro se in a serious criminal trial will naturally be focused on their rights and the potential impact of proceedings in their case. On their case. They will question things they don't understand. However, the pattern of Lori's interaction, her persistence in the face of clear judicial explanation, her framing of requests as entitlements, and her somewhat dismissive or challenging tone towards the judge's authority may point towards underlying narcissistic tendencies. She appears to believe her interpretation of rules and her needs should take precedence and struggles to accept when they are not met. So that's what it had to say. Very fascinating. And yeah, her main complaint was in this, it says Lori Vallow Daybell's main complaints in this argument revolve around two interconnected issues concerning the state's alleged aggravators in her non-capital case. She believes she's entitled to a pretrial probable cause hearing for the specific aggravators alleged by the state, and she doesn't understand the purpose or necessity of a separate aggravation phase after a potential guilty verdict. especially if the sentence for the charge is fixed and the crime is already considered dangerous. So she feels the process is procedurally unfair because she's being denied a preliminary review of the aggravators, and she views the subsequent aggravation phase as redundant and without a clear impact on her potential sentence for this specific charge. So that's according to AI. Pretty interesting. Are you talking? I don't hear you.
Do you hear me now?
There you are. Okay. I hope I wasn't talking over you just now, because
Nope.
yeah.
AI can be wrong, but
It can.
I don't think it's wrong here.
Yeah.
It
does it quickly,
thought.
just it's not to take over anybody else or anything.
All right. So we have a couple of documents that we need to look at, and some people in chat have been waiting for these documents. One is from the state, and two of them are almost identical documents from Lori herself. So we'll take a look at the one from the state first, because I think that's, it's just easier to do that. It's easier to look at
one of them. Yeah, I mean, we have to do all of them. So
exactly. Notice of missing pages of notes. These are all three of these new documents that came down today were regarding the forensic investigator Tammy Lachcik with the Gilbert PD. Yeah,
she has the envies for her, huh? Envies meaning like she's got something. She's preying on. It seems she's preying on, kind of like she did with Trina, character assassination in a sense.
Yes, it seems that way. That's how Lori is handling it, but the state also has something that can't just be swept under the rug in this document. On December 12th, 2023, the state disclosed the supplements, the list of impounded items and notes created by Tammy Lachcik. Bates 11-844, 45, 39 to 43, 1913 to 1915. I don't know what all that means. That's crazy talk. Bates 2059 to 2063 are 5 of the 7 pages of notes prepared by Gilbert Police Department criminalist Tammy Lachcik on November 18th, 2019. So Kresha, tell us, when was November 18th, 2019 relative to when the JJ and Tyler went missing and when they were found?
Yeah. Okay. So September of 2019, on September 8th, or in September 8th is the last day that Tylee was seen alive at Yellowstone National Park. And JJ was last seen alive with a photo located in Lori's iCloud account of him sitting on the couch in his red pajamas. Just seemed to be being a good child. That was September 22nd, 2019. October 2nd is whenever, well, actually September 26th, 27th, 28th, and 29th is whenever Melanie Boudreaux-Pulowski flew an Allegiant flight number 608, I believe, to Rexburg, Idaho, where she spent a couple days, and then she returned on September 29th, 2019. Then we know that October 2nd, somebody driving the Jeep, who we believe is Alex Cox, Lori's brother, took a shot at Brandon as he was returning home after he dropped his children off at their respective schools, and then his younger two, or one or two, it's different in different places. So he for sure dropped his younger child off that he shared with Melanie. So you can I'm saying that because it seems to be a pattern of bad behavior around Lori Vallow Daybell whenever there's a kid exchange, that seems to be whenever attacks are launched upon whomever she's pissed off at. So Joe Ryan, whenever he was doing a kid exchange for Tylee, that's whenever Alex attacked Joe Ryan with a taser gun. And then whenever Charles was doing a kid exchange with JJ that morning, he was going to pick him up, bring him to his hotel for breakfast, and then was going to drop him off at school, not go to effing Burger King. Okay. And so I'm just saying that so that kind of, I don't know. You can let me know. You can do whatever you will with the information. But, and then, so October 2nd, that happened. A shot was fired at Brandon, missing him by inches. And then, like October 3rd, Melanie Boudreaux Pulowski, before she became Pulowski, was interviewed by Gilbert police officer Detective Coons. And she couldn't recall where she was the day before, which is a bit, I mean, I'm just like, really? You can't even make up anything, girl? Okay, so then October 8th and 9th, well, October 9th, a shot was fired, or Tammy Daybell was unloading her vehicle. She had just got back from somewhere where they do freezer meals or something like that. She had just got back from that, and instead of parking in the driveway where she normally parks, she parked on the side. And so that could have maybe saved her life that one day, and called Alex, who they presume is the gunman for that day. There's argument whether it was a paintball gun or not. I don't give a shit what it was. It was torture. Okay. Straight up. This group is sadistic. So that was October 9th. Okay. And then Tammy ultimately died October 19th. Okay. And then November 5th, Lori and Chad get married in Hawaii. There were like, I want to say Justin Lum said there were 666 wedding photos. Nobody else was there. Nobody wants to see them, first off. So just saying. That's just me, though. And then, so November 5th, they also, after that, they went and, okay, so after the welfare check, November 26, 2019, they skedaddled. Okay. They got the hell out of town. But as they were going out of town, Lori and Chad, Lori met up with Chad later at Knott's Berry Farm or whatever with Chad's kids. It was like a vacation time, right? Which is very weird. Very weird, especially knowing that Tylee and JJ were dead and cold, very not too far apart from one another on Chad Daybell's property at this very time. Chad's kids are getting awarded or rewarded with a vacation. Guilt, perhaps, I would say. That's something I believe like narcissists tend to do. And I'm just saying this, I have no basis for it, but they tend to throw money at their kids. Like, here, money will entertain you. You know, I don't have to. But I still get to be exalted, so to speak. But so I know that Detective Ray Hermosillo started doing surveillance. I want to say it was November 4th, 2019. And yeah. And so he did surveil that. They saw Lori and Chad walking, holding hands together. There's been testimony of that as well. And I mean, this is right after. So Tammy died October 19th, 2019. And then Lori, whenever Charles was murdered, she did not end up getting the life insurance policy. That was part of I believe, some of the resentment towards my mom, thinking, and they've even said things like Kay changed it or something. And I'm just like, that's not how that works. And it's like they're taking it out on my mom because Charles changed it. You know, it's just like, what? Anyways, I don't quite get that. But I think that's partially the motive of why I think JJ and Tylee were doomed anyways. Like, that was the plan because they're sadistic assholes. But was to just do away with the kids anyways. And it was like after all the money was confirmed, you know, like she had obtained rights to put her hands on their money, and money that she was collecting for killing Charles. Basically, she would have never gotten the Social Security money, for Charles, because she murdered him. Okay, so that shouldn't even came into play, but it did. But it's like once she obtained the rights to their money, she did away with them in that order. Soon, like it was quick. And so it seems like at least part of the motive for her with Brandon Boudreaux, as far as killing him, what are her motive? Like, what would be the reason you'd want to kill your nephew-in-law, estranged nephew-in-law at that time? And it's to obtain money, like October 2nd is when they shot at Brandon, or when he was shot at. So this is before Tammy's dead. This is before they got the $435,000, or Chad got the $435,000 for Tammy's death, which is also blood money. Which, if you look up the video of Nate Eaton approaching Chad and Lori while their vehicle was impounded, okay, and that's anyway. So whenever they're walking into the hotel or to the hotel, because they had no wheels, right? It got impounded. It was a prime opportunity for Nate Eaton and Eric Grossar to ask them questions. Where are your kids? Everybody's praying for you and your kids. And she says, that's great. And then Nate at the very end, he notices, why do you have a baggie full of money? And it's so awesome. Yeah. I mean, just puts him on the spot. So that's just off the top of my head.
That was a lot that's on the top of your head.
Yeah.
That was a lot.
A lot.
That's a lot.
She's a lot.
She is.
Yeah.
So this filing.
Did I throw you off kilter? I probably did.
A little bit, but I'll get there. Tammy Lachcik is like what we're trying to take a look at.
A crime scene law enforcement officer, I guess you could say, right?
Yeah. Yes. And so the state filed a motion to file their motion under seal, and Lori kind of filed her own motion that unbroke the seal. And I'm just struggling a little bit with like, how much do we share that? Because it is public record.
Mm-hmm.
But it is.
Yeah, I remember Alistair Adair. Alistair Adair. I remember her being like was she a prosecutor at that time? I don't know. I remember saving news stories from that time because she died soon after. But she was involved in this case. But she had fight with alcoholism, and I remember reading stories about that before. And somewhere, I don't know where I saw, but is Lori like accusing Tammy Lachcik of alcoholism or something? I don't even know where I got that.
Yeah.
And it's kind of like with Trina K, how she was saying that she was with, who was the Juan Martinez, I guess, is the attorney for, or the prosecutor for in the case against Jodi Arias. And I'm just like, why are you doing that? Like, the character assassination that's trashy to me. Like, you don't have a decent point, do it without trashing somebody else. Trashy.
And that's where this goes. That's totally where this goes. So I have mixed feelings about it because it is public information, but I mean, we can share and comment how we share and comment. Yeah.
She brought it up. Let's just say that.
All right. So we'll wrap up this motion. May 15th, the state realized it was missing pages 6 and 7 of Tammy Lachcik's notes. The state reached out to Gilbert Police Department, the Phoenix Police Department, and Mesa Police Department to obtain the additional 2 pages. The state was advised that they had searched all their databases and they couldn't find those 2 missing pages. So that
Mm.
may be a problem. Like what level of problem it is, we don't know, but it could be a problem. Like,
I mean, it was a big deal in the Delphi case. Remember the missing paper that was at the bottom of or whatever, the filing cabinet, and that had Richard Allen's name
oh my
on it.
gosh.
And
Kathy
she got
Shank, yeah.
did she get a reward or something, even like monetarily, and just all the things, and you're just like, wow.
You're gonna
I
take
know.
me to Kathy Shank. Yeah, you're taking me back there.
Yeah.
Oh my gosh.
It just reminded me of that.
I actually met her in person at the trial.
Hmm.
She was on the 3rd floor and she started walking down the stairs. And Indiana has these old courthouses, like really old courthouses, 19th century. And
Yeah.
she was walking down the spiral marble staircase and she tripped and almost fell down. So I had to catch her. I had to catch her and help her back up. And I didn't even know who she was at the time, but she was a state's witness.
Yeah.
And she was a very important state's witness at that.
Yeah. But it just reminds me about how these different pages or things, information can be.
Yeah.
Especially if you're lost,
All right. Arizona Rules of Criminal Procedure, Rule 15.43, provides that handwritten notes are not a statement if they were substantially incorporated into a document or report no later than 30 calendar days of their creation. I don't even know what that means. Do you know what that means?
Yeah, I mean that they have 30 calendar days to put the handwritten notes into a statement, and so this doesn't apply to that because it was put into a statement, right?
It appears to be so.
Okay, so she meant to she meant to put Lori sucks is what she meant to put.
Queso is the Spanish word for cheese, and that goes with green chili chicken enchiladas.
Oh,
we need
God.
queso with those. All right. Do we want to look at the other documents?
Yeah, we're here.
We're here.
We're here.
Stop screen.
I meant to say bye, B-Y-E. I spelled it wrong, Lamisa. I put B-Y. Bye, girl. Bye, Lamisa. Sorry.
Okay, so 2 of her objections are almost identical. They're both 19 pages long. One of them says, defendant's objection and request to unseal the state's motion in limine, and the other one says, defendant's response to the state's motion in limine to preclude inadmissible evidence. So these are identical filings with just different titles.
Okay.
So we can look at either one, but they're both 19 pages long, and the only difference is the title.
So it's like they did it twice and titled it differently?
Yes, absolutely.
Okay.
Here is the objection and request to unseal the state's motion in limine to preclude inadmissible evidence relating to Tammy Lachcik. Buckle up because this is nuts.
My God, my throat. I have the Vallow. It sucks.
The defendant, Lori Daybell, respectfully requests that this court deny the state's request to seal the state's motion in limine to preclude inadmissible evidence relating to Tammy Lachcik, the information of incidents dated December 30th through March 6th of this past year. of former forensic technician Tammy Lachcik is information that is relevant to the witness's mental state, credibility, inaccuracy, probabilities, and any probative value would be outweighed by unfair prejudice. The defendant requests that the record be unsealed. The defendant will show support to claims in the below memorandum of points and authorities. This is the meat of the matter. Do we see? Okay. I'm gonna scroll down just real quick just to make sure that
I see fruits of a poisonous tree.
Yes. Page 10 is where Lori starts talking about when she saw the body worn cam.
I wonder if we're gonna see it, because we don't have that, I don't think.
Not yet.
Not in the public domain.
Somebody may file a FOIA request for that. I don't know who might that be.
I will.
All right. Memorandum of points and authorities. The state's former expert, Tammy Lachcik's credibility is crucial in the case. Gilbert Police Department's inter-office memo from Chief Michael Solberg.
Okay. Dated March 6, 2025.
Yeah, but she didn't.
Oh, internal, right. Maybe?
Gilbert Police Department General Order 11810 subsection 321.5C, violation of any federal, state, or local or administrative laws, rules, or regulations, ARS 13-2412, refusing to provide truthful name, check in under Tammy Stoltz, her maiden name.
I do this all the time. Okay. I got social security cards for all of them. I do. I try to go with the one on my license, you know.
Gilbert Police Department, General Order 11810, subsection 321.58C, failure to participate in or giving false or misleading statements or misrepresenting or omitting material information to a supervisor or other person in a position of authority in connection with any investigation or in the reporting of any department-related releases.
She would have been terminated.
Gilbert Police Department General Order 11810 subsection. I need to say that like 5 times fast. Subsection 321.5.
I remember semantic. I remember that word. I could not recall the other night, and I said it 5 times just so I remember it now. So
subsection semantics. Subsection semantics.
Yeah.
321.5.9.74, conduct unbecoming a member. On paragraph 5, the recommendation of dismissal of FSS Tammy Lachcik from employment with Gilbert Police Department. If she had not resigned, she would have been terminated.
Okay. So what is Miss Tammy Lachcik's former employer investigated Ms. Lachcik's ethics and credibility in the above facts, providing false, misleading statements, misrepresenting, and omitting material information, especially for the purpose of investigating ARS rules of evidence, impeachment by evidence of criminal conviction in U.S. versus Hunt, 562, whatever. Detective knowingly made false report entries and with the intent to impede, obstruct, or influence of investigation, gives that code, destruction, alteration, or falsification of federal investigation. Falsifying a police report is a federal document, and it gives a code. Perjury in general, another code. Fruit of poisonous tree doctrine, another code. A reason to doubt. The suppression of evidence and the inference of innocence. Miss Tammy Lachcik was at the time of incident a officer and member of the Gilbert Police Department of offenses and U.S. versus Mixon on Bates 101015. Miss Lachcik's alcohol content is 0.157 after allegedly 8 hours of last consumption of alcohol. Damn. On Bates 10, I'm not going to say all those things. The number in Ms. Lachcik's interview recollection of event, she struggles with memory loss during the questioning or investigation. One, they give a Bates number. Ms. Lachcik works for a government agency. She is in a position which requires her to testify in serious criminal matters. That's in quotes. Ms. Lachcik states, quote, where she was mentally as far as having a mental breakdown, unquote, as on Bates number, blah, 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 with alcohol and isolation. Ms. Lachcik admits to alcohol use and isolation as her form of coping with alcohol, mental state and isolation, effects to memory loss, mental illness, and alcohol abuse. This exposes Ms. Lachcik's competency to perform her duties on prior cases she was involved in, creating inaccuracies and false conclusions. On Bates number, blah, 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 Ms. Lachcik's son stated, quote, she gets really, really, really drunk, unquote. Quote, it's been going on for years, unquote. Bates number, this one, it says, quote, 2 750 milliliter liquor bottles and about 10 shooters, unquote. On Bates, this number, the condition of room was observed and described by Officer Camarillo, I think is how you say it, quote, trash, several empty liquor bottles, and vomit, unquote. This incident is a public record. And it says on October 9, 2019, Ms. Lachcik photographed and processed DNA swabs and the GSR kits in Rexburg, Idaho's impound effing lot. Great. As the above facts from an internal investigation into Ms. Tammy Lachcik state, the expert's credibility is tainted. Ms. Lachcik's long history of alcohol abuse and self-isolation in hotels raises the issue that Ms. Lachcik may have been under the influence. As Bates number, yada, yada, she lacked hygiene care and has been coping with alcohol to cope with her mental state of mind. Bates number and Bates number. The inaccuracy probabilities of cross-contamination of evidence are high given the years of alcohol abuse, which have affected Ms. Lachcik's memory. This manifests fundamental unfairness and violation of due process. In State versus Bowles, 1995, Maricopa County remanded. The testimony regarding the probability of a random match is inadmissible. Admission of improper testimony regarding DNA testing and probability of a random match being tainted. Contamination, whether intentional or unintentional, could have occurred. Sample could have been contaminated by upset forensic expert regarding Rossum versus Patrick. And that was in 2011. Ms. Lachcik, forensic processing of the alleged crime is crucial for the breach of probable contamination, which addresses why the state is using Ms. Lachcik, who was forced to resign due to the similar offense based on character and credibility, as the state is implying on the defendant. The state lacks the evidence and truthful expert testimony. Ms. Tammy Lachcik is an alleged witness. Prior cases Ms. Lachcik was involved with can be reopened based on the above. Questioning every case. Fruit of the poisonous tree doctrine, State versus Bravo in 1988, exposing inaccuracy and collision prevent witness from tailoring statement. Not admissible is hearsay residual exception. In Mike versus, who the hell, M. Ross? I don't know. 2014, the prosecutor's duty to learn of any favorable evidence known to the others acting on the government's behalf in the case, including police. Both prosecutor and police cannot get around, quote unquote, Brady. the state's breach of its constitutional duty to disclose evidence or impeachable evidence, yada, yada. In addition, violations of 170 AM jury trials, litigation of allegations of falsified or fabricated physical evidence in criminal investigations and prosecution 2024, blah, 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 tampering with evidence criminally 2024, and 18, I don't know what AM stands for, American maybe? I don't know. Whatever. Okay. Intentional spoliation, that's a weird word, of evidence. Obstruction of justice, because character evidence is slight probative value and may be prejudicial. The evidence bears directly on the charged crime. The court will fail to balance probative value evidence as compared to its prejudicial effect. Therefore, denial of due process regarding U.S. versus Wells, 879, 2018, reversed, remanded. Deliberate fabrication of evidence by a state official is in violation of the due process clause of the 14th Amendment if evidence that officials continued their investigation of a person despite the fact that they knew or should have known that she was innocent. The investigator has an quote-unquote unlawful motivation to frame an innocent person. Okay, another code, and it says destruction, alteration, or fabrication of records, documents, or tangible objects. Under confrontation clause, the defendant has the fundamental right to confront her accuser. The prosecution is knowingly soliciting false evidence or false testimony that will compromise the outcome regarding Glossip versus OK, and that's in 2025, reversed, remanded. I got a lot of examples here. And it says the government's failure to assist the defense by disclosing information helpful to conducting cross-examination is a constitutional violation which deprives the defendant of a fair trial. Regarding U.S. versus Baglett in 1985, Brady Rule violation, the state will violate Rule 404B, Rules of Evidence, Rule 403, unfair prejudice by depriving the expert to prior acts into evidence, depriving confrontation clause and due process, but confusing the issues and misleading the jury by the above facts. ARS Rules of Evidence, Rule 613, witnesses' prior statements, ARS 38-311, offers subject to impeachment. Rules of Evidence, Rule 608B, a witness's character for truthfulness or untruthfulness, specific instances of conduct. Additionally, is hearsay. Rules of Evidence, Rule 801, and not admissible. 17 AARS, Rules of Evidence, Rule 806, attacking and supporting the declarant's credibility. Confrontation clause protects the right to a fair trial by requiring that the defendant have a right to confront any witness who testifies against her. In State versus Hughes, 192, Arizona, 1998, the prosecution has an obligation to refrain from using improper methods to obtain convictions. The rules of professional conduct prohibit lawyers from engaging in conduct that is prejudicial to the administration of justice. And it gives another law or code, whatever case, I don't know. And it says regarding matter of Martinez, 248, Arizona, 2020. So the conclusion says, based on the above finding, as the defendant has established, the defendant requests that this court grant the defendant's objections and request to unseal state's motion in limine to preclude inadmissible evidence relating to Tammy Lachcik, whatever, Lachcik. I forget how I said it earlier. Anyways, this court is obligated to grant the defendant's request. Quote, fundamental error is reversed where such errors are found to be prejudicial to the defendant, unquote. Regarding State versus 1985, quote, fundamental error is error that, unquote, goes to the foundation of the case or takes from a defendant's right. Defendant's right. Okay. Takes from a defendant's a right essential to her defense. State versus Wessler. What a name. And this, so yeah, finished that in 1984, and it says dated this May 25th, 2025, which was JJ's birthday, and Lamisa.
Oh, good
Yeah.
Lord.
Lori
Good
Daybell.
Lord.
Pro
Oh my
prayer.
gosh.
I'd have to run that through my AI to even know what it all said. I mean, just for it
I
to just run it down.
yeah, there's no way. There is absolutely no way. No way.
Like, I'm not a
But
lawyer, so I don't speak this at all. But I don't know if you have this uploaded into the link you shared with me before for the Dropbox. If you do, I can do that with you. Maybe go on to the next one or something. But this chat room is amazing. Thank you for saying that, Moose Girl. I'm partial, though. Her actual trial starts June 2nd, which is Monday. That's when opening statements start. We have jury selection tomorrow. I will go live during that time. I was so out of it, y'all. I didn't even register in my brain that, to go live today at all. Then I'm like, oh, okay. I had to sleep and reset. Do you have this in the Dropbox link that you shared with me before?
I'm getting there. Give me 2 minutes.
Okay. Not a problem.
It will be there. It'll be there. It'll be
Allegedly.
there.
I always say allegedly. Yeah. Let's see. I'm trying to run through anything I had pulled up on my. Oh, I have tons of papers right here of written notes. We can talk about Melanie Pulowski and the things that I've decided to write down about her.
Oh my Lord. No.
So like back in when was this? I don't remember when this was. I want to say November of 2021. New details in Mesa PD's identity theft investigation of Pulowski alleged she used a copy of a $12,000 check deposited into Boudreaux's business bank account to present as an exhibit during a family custody hearing. Boudreaux and Pulowski went through a long court battle over their 4 children after their 2019 divorce. So I put that on there for some reason.
All right. Dropbox is updated.
Okay. I'll jump on that.
That was very Lori-esque. Okay.
I'm right on top of that, Rose. Yeah. I never want to be like her. I'll talk like a damn man if I have to. I don't want to be a mousy voice. She's ruined everything like that. Okay. I wrote this down too. The cult and its practices and visions of glory. Divorces complicate insurance schemes and also looks bad when trying to retain or recruit cult member and future members. Read the book of Job. These types thrive off that whole storyline about overcoming great tragedies, etc. Pumps them up in their peer group to suffer. The humble brag runs strong in these people, bragging about how much adversity they preserved through, etc. And it says Lori did not change the password to CV's life insurance. He did. Like, he didn't realize, like, she had him that discombobulated, I guess, that he didn't, like, she actually did not lock him out of it. I remember looking over that more than once because I was like, what? I thought she did. I think Nate Eden talked about it too. From Visions of Glory, once these evil spirits had total control, they then desired that the mortal should quickly depart mortality so that their possession became permanent. Anyways. Also, this is interesting. Well, okay. And so these are just notes I took. And so I asked, because these names were listed in one of, forget the name of the detective, that testified in both Lori and Chad's trial, but he talked about how there was these notes taken, like whenever they impounded the vehicle that Lori had, you know, there was like the Visions of Glory book. There was, I want to say $10,000 in cash. There were like 14 or 15 copies of death certificates from Charles's death. She had multiple copies of the kids' birth certificates, things like that. And so this was also included on a note, and it said Blake Hiplos Brandon ANGO. I don't know how to say that. Ango. Go Mad ×2. Hope Brighton Ilron Gladius. And so if you just think about it, Blake was one of Melanie and Brandon Boudreaux's kids. I think he was a 4-year-old at the time. And Brighton, because it was her 2 middle children that were deemed dark, so to speak. And so Detective Hope's name's on here. You got Hiplos, that was Uncle Charles, allegedly, they say. So I asked, I'm like, are these sigils or demon names? Like, this detective is from Hawaii. Nesbitt is his last name. Talks about serving a search warrant to search vehicle, condos, any evidence looking for missing children. And that's from the Lori Vallow trial. Officer testifies against so-called Doomsday Mom. Full audio May 4th. But I also noted that Joseph Smith was involved in a French/Canadian Masonic Lodge. Joseph Smith joined that. What Masonic Lodge? Okay, it says, what Masonic Lodge did Joseph Smith join? It says the French-Canadian one. What Native Americans did they say to inbreed with? And it says Micmac. Okay. Templar flag, red, white, sun, moon, and the star. It's a red cross. The Micmac chief went into a 7-day battle, and he and his wives were even buried at a star fort. I don't know. Some of these things I shouldn't repeat. But anyways, I'm gonna run that through. Oh, whoa. This is interesting. This is important and grounded in evidence. So 10-1 on the I-40 at 0652, a gray colored hardtop 2-door Jeep Wrangler with Texas license plate, whatever it is, captured driving toward Phoenix metro area. There was no wheel affixed to the rear of the Jeep. There was an image captured approximately 26 hours and 30 minutes prior to Brandon's attempted homicide. 10/28/2019, Brandon contacted me to advise. So this is from the report. Contacted the detective to advise that he would be moving to Utah to stay with his parents for the foreseeable future. 10/29/19, the detective contacted the Madison County Sheriff's Office about Tammy Daybell's death. They did not have on record referred to Madison County coroner, who also had no record for Tammy's death. After reviewing the obituary forwarded by Brandon Boudreaux, I called the funeral home. I was referred to the Fremont County Sheriff's Office and requested police report number 2019-03397, then spoke with coroner Brenda Dye, to which she stated no autopsy was performed. This is interesting right here. Coroner Dye asked if there was something suspicious with Tammy's death. I told her I was unsure. It says in 10/29/2019, unsolicited, Coroner Dye shared that she spoke with neighbors of the Daybell family. The neighbors referred to the Daybell family as, quote, extremely religious, unquote. And there were recent reports of people meeting to plan for a, quote unquote, doomsday event. How creepy. 11/1/2019, GPD communicated with Fremont County Sheriff's Office and Rexburg Police Department. Detective McDermott from Arizona spoke with Fremont County Sheriff's Office Lieutenant Powell. Isn't he on the witness list? I don't know. Who located Lori Vallow Daybell and Chad Daybell. Lori Vallow Daybell appeared to reside at redacted apartment number redacted. So that's probably, the apartment complex where they lived, number 175. They had her address as of this date. So 11/1, they had her address. Could not locate Alex Cox or the Jeep Wrangler, but tasked Ray Hermosillo with Rexburg Police Department with locating both. November 4, 2019, Detective Hermosillo located the Jeep Wrangler. The Jeep was towed from the scene and impounded in a secure law enforcement lot used by Rexburg Police Department. This goes with Tammy Lachcik or whatever. No persons were contacted, nor did anyone follow up about the Jeep's status during or after the tow/impound. So, like, Lori never did reach out and say, hey, my daughter's Jeep is missing, which is very telling. On 11/5/2019, Detective McDermott, this is when Lori and Chad get married in Hawaii. And it also, Detective McDermott interviewed Claudia and Brandon Ewell after it was learned Melanie Boudreaux and Alex Cox went to the Ewell residence on 11/1/2019 to locate Melanie's children. Mel said the Holy Spirit told her the children were there. And that's that video I re-uploaded that it has 16,000 views. I was like, wow. And it, where her and her uncle show up. I think you shared it because I added video to it, even though it's not the video from that. It just shows a pattern too, that Melanie and Alex, they would show up at whomever's house and he would park down the road a little bit and just kind of be a surprise, very, very weird, very creepy. And then this one's kind of out of order, but it says 10/1/2019.
McDermott is on the state's witness list, by the way.
He is, but not Powell.
Hold on.
I know Hermosillo is.
No, Powell, Nathan Duncan from Chandler, Mesa, Milky Perry, Sapanoso, okay. Mueller.
That's in the Gilbert report.
Yeah. There's nope.
Yeah. There's no. I'm just picking. Messing with you. Okay, so this one's kind of out of context or out of the timeline, but it says 10/7/2019. Melanie was still on Brandon's accounts. As a result, Brandon transferred funds to a different financial institution. 10/7/2019, Melanie contacts Gilbert Police Department for first time since her initial interview on October 3rd, right? And then it says she tried taking her kids out of school early and learned that Brandon had not taken them to school. The investigator denied knowledge of Brandon's reasoning and explained the equal custody of their legal marriage. I believe he was helping, because Brandon kept in contact with the detective to let him know what he was doing, why he was doing it. Melanie said no new information developed since her initial interview on the 3rd. Detective asked Melanie about her desired move to Idaho because it came out of nowhere. She replied it was an unplanned location and fresh start. Melanie reiterated her belief that Brandon was manipulating and threatening her in an attempt to disrupt her relationship with Lori. Melanie could not produce any details or evidence of Brandon's threats or manipulations. Same as Lori. It was very generalized, very vague, he's just sending me all these threats kind of thing. But nowhere did she produce any kind of evidence to back those up.
She never does. She never does.
But Melanie's is the same way. Very vague and just whatever she's having to do to justify getting a divorce and to go be on board with her Aunt Lori. That's what it sounds like. Page 1, Boudreaux conspiracy. Okay, I wrote this May 22nd. It says, in the weeks following the murder of Charles Vallow, investigators learned that Charles and Lori Vallow were experiencing turmoil in their marriage. As a result, Charles moved Lori into the residence on Four Peaks Place with Lori's daughter, Tylee Ryan, and their adoptive son, JJ Vallow, who was diagnosed with autism. This came from a report. Charles Vallow remained in Texas and came into town to visit on July 10th, 2019. When looking into the relationship between Lori and Charles, it was learned that Lori had accused Charles of infidelity, which led to their separation. It was also learned during the uncertainty of their relationship, Lori left JJ with Charles and disappeared for over 2 months. On October 3rd, 2019, the Chandler Police Department learned of the attempted murder of Brandon Boudreaux. On 10/2/2019, Brandon reported that someone shot at him while he was sitting in his vehicle in front of his Gilbert residence. He indicated that the shot was fired from the back of the Jeep Wrangler parked down the street from his residence. Brandon suspected that Alex Cox was the shooter. Brandon further indicated that Lori Vallow was to blame for his impending divorce from his wife, Melanie Boudreaux. Brandon then provided authorities with insights into the extreme religious beliefs of Lori Vallow and Alex Cox. Brandon suspected that these beliefs led him to lose his wife and also led to the murder of Charles Vallow. And I'm sorry, I just have snippets here. It's just like when you do read the actual report, it takes away all those doubts I have. You know?
Yeah. 100%. Yeah.
Oh, this was from body cam that was released or that we saw during Chad Daybell's trial, I think. Anyways, whenever we were shown the body cam footage of Detective Ron Ball going and knocking on Lori's door, I think we watched it a couple episodes ago, you and I. You know, it's hard to see because it's like they're showing it on the projector in the courtroom, and so it's like a video of that, and so it's really bad. But it says several credit cards for Brandon Boudreaux, along with an Arizona driver's license for Brandon Boudreaux, was located in Melanie's. I want to say Melanie's apartment, but I don't know that for sure. It's either Melanie or Lori's. Body cam video footage of Lori Vallow's apartment number 175 of a Lori Ryan lease agreement left on a printer that was upstairs in one of the bedrooms. Detective, I want to say it was Consitus, big guy, said it appeared was left in haste, opposite of what was reported by Melanie Pulowski in interviews done in early part of 2020, prior to Tylee and JJ's bodies being found on Chad Daybell's property. And so I don't know why I wrote this, but I said, look into anti-marital fact privilege or spousal privilege. In Arizona, if a person is charged with a crime, they can prevent their spouse from testifying against them, even if their spouse wants to testify. The rule is called the anti-marital fact privilege or spousal privilege. But like in Idaho, that goes away because children are involved. And I mean, it should be the same for Brandon because children were involved. You know, if you think about it, because her children were, Melanie Boudreaux's children, 2 of them were dubbed Dark, Blake and Brighton.
Yeah. And they're alive today because police at some point in time, at some level, police did their job and
because of media and because of Brandon's, you know, he kicked into gear and he knew that Charles was murdered. You know, him and Adam tried telling Melanie Boudreaux on the phone that your Uncle Alex and your Aunt Lori murdered your uncle, basically murdered Charles Vallow, my uncle. And she looked at that as Brandon trying to sway her, you know, to demonize Lori, basically, which, I mean, holy crap. I've wrote on here, okay, text about Melanie accepting the fact that this is alarming. Okay, I remember writing this down. I just don't remember where I got it from. Maybe it'll come to me. Text about Melanie accepting the fact that 2 of her 4 children were, I put, to be sacrificed for the greater good, just as her younger little cousins, Tylee and JJ, had been right around the same time frame, and how Lori tells Chad Mel was coming to terms with it, but that Lori was struggling worse than Melanie regarding the apparent agreement or arrangement to kill or sacrifice Mel and Brandon Boudreaux's 2 middle-aged kiddos. And I put the Tesla Edgar text exchange is also alarming. And then I wrote Janice and Lori talk over 90 minutes smack dab during the same time frame as Brandon Boudreaux's shooting. I want to say it was October 1st. Because that's when Janice claimed that she had actually talked to JJ, that she said something along the lines of, because he knows me, he called me Mimi. But in fact, JJ was not alive during that time. She even produced phone bills or whatever to ABC Family. And that's where we got that from. Then, the bullet having to move over 5 inches. Oh, I cuss even in my notes. The huge effing fact that Melanice was super obsessed with effing portaling, remote viewing. Melanie Boudreaux is one of the 7 gatherers. Melanie's interactions with her dad, Steve Cope, especially about visions of the G meter in the temple, and that she told her dad to get his own revelation about Brandon. The Yule's audio and the Holy Spirit justification. The Gadianton angle, similar to Nephi. And I put, what was the effing end game here with all these yo-yos? To be translated beings? Just living their best Mormon celestial life with 0 kids? New husbands? Is this what is meant by living more celestialer? They do say that, celestialer. In preparation for, oh yeah, let me sway off that. What, if anything, did Melanie's involvement with anti-trafficking involvement consist of exactly? Just her by herself? Or was that connected to Brandon also? Was it Tim Ballard's anti-trafficking organization or a different Mormon alpha doucher? But I'm so sorry. Anyways. Okay, so November 2021, Gilbert PD recommends attempted murder charges to the Maricopa County Attorney's Office to be filed against Vallow and Daybell, Lori and Chad, who were believed to orchestrate the shooting. Prosecutors chose not to charge Chad Daybell, and Vallow's case is still being reviewed. Charges for Pulowski were not submitted to MCAO. Okay, so Melanie Boudreaux, 10-16. I don't know.
Why not?
I don't know what their tactic is. I don't know why they're doing what they're doing.
All right. I'm gonna offer a swear word on my channel, and y'all just gotta put your earmuffs on. Why the fuck not? Why does she not have
yeah.
Why
is she allowed to? Yeah. Go ahead. I'm sorry.
No.
You got to get it out your system.
Yeah. Why the fuck not? Why is she not charged in any way, shape, or form with any participation in this? When it's her husband. Yeah. Her husband was shot at by her aunt's brother.
Her aunt and uncle.
Her uncle. Yeah.
Yeah.
Right. Yeah.
And then she was colluding with them or visiting with them. I mean, in the 4 days leading up to, 6 days leading up to, from September 26th to September 29th, 26, 27, 28, that's 4 days. She was in Rexburg. There's not going to be any communications really, I would think, during that time of Melanie. But there are plenty that are very questionable where she's asking, if to start working on Brandon. I do have those uploaded to my channel. Just little blurbs, where prosecution is questioning people in the trial. Oh, Detective Hart. I'm sorry, Special Agent Hart. He's going to be there. He's subpoenaed. I'm going to go to my channel real quick and see if I can grab that super fast. Because it's telling to me. In my layman opinion. Let's see. Videos. Okay. I also uploaded one about the Brandon Boudreaux, the Gadianton robber. Gadianton robber exposed how Lori Vallow's inner circle demonized Brandon, according to their belief in Gadianton robbers. Which we've heard that plenty in Bishop Glenn L. Pace accusations and stuff, or his report. Okay. Here we go. This is a little minute and 21 second. If you don't mind me sharing.
No.
Oh,
Come on.
I hit the wrong
Bring it
damn
up.
thing. Roll that beautiful bean footage, huh? Okay,
There
I have
we
it
go.
on there. All right, I'm not even gonna widen it, so it's very short.
All right, add this stage. Did we not add the stage? All right, here we go.
Oh, was it not on there?
There we go.
Ready?
Now we're there.
Why did you include
Yep.
this series of communications between Lori Vallow and Melanie Boudreaux?
I included this for context purposes because it is a similar conversation relating to Brandon Boudreaux with references for could he go similar to what we've seen in other communications. Line 663 from Lori Vallow to Melanie Boudreaux. Yeah, but until that agreement is signed by the judge, it is all subject to change. That's probably the reason for the delay. Line 662 from Melanie Boudreaux to Lori Vallow. Is there a possibility he could go before I move? Line 661 from Lori Vallow to Melanie Boudreaux. There's always that possibility. We will work on it. Just have faith and do whatever the Lord tells you. He is always right. Line 655 from Melanie Boudreaux to Lori Vallow. I don't recall the words to get him out, but should we try? Line 654 from Lori Vallow to Melanie Boudreaux. I know them. I'll work on it now. Put all your energy in. Line 647 from Melanie Boudreaux to Lori Vallow. I've worked on them all day and evening. Line 646 from Lori Vallow to Melanie Boudreaux. Me too. He's got to be ready to go. Line 645 from Melanie Boudreaux to Lori Vallow. I know.
Is there anything else you want to review with the jury on why you included the text communication between Melanie Boudreaux and Lori Vallow from October 14, 2019?
No.
Golly, everybody's over at Hidden True Crime right now. Right there. Okay. Love being railroaded. All right. Let's see. So this is to do with Edgar, okay, and Summer, a guy that we believe that Summer was cheating on her husband with, allegedly. I don't know that for a fact, but I'm just speculating. But this is very, very disturbing. Hello and welcome to my channel. My name is Cresha K. Easton. I am the daughter of Kay Vallow Woodcock and Larry Woodcock. I am the aunt of JJ Vallow and the niece of Charles Vallow. I've been getting a lot of messages in regards to Chandler Police Department's investigation that came out through the FOIA request, a few text exchanges between Lori and her sister Summer. Nate Eaton of East Idaho News invited Summer Cox Shiflett to be his guest at CrimeCon. I'm going to read the text exchange between Lori Vallow Daybell and her sister Summer Cox Shiflett. Looking on page 314 of the Chandler Police Department FOIA docs, I'm going to read a small excerpt, text exchange between Lori Vallow Daybell and her sister Summer Cox Shiflett. In both of Lori's accounts, she had regular communication with her sister, Summer, who was listed in her phone as, quote, some, unquote. The number linked to Summer was blank. Summer also shared Lori's religious belief. I'm going to repeat that. Summer also shared Lori's religious beliefs. On 10/7/2019, so this was after Brandon Boudreaux had gotten shot at, Summer sent Lori a message asking if she already knew about the Tesla incident. I'm reminding you that Brandon Boudreaux drove a Tesla. Lori responded at 15:51 hours, indicating that she did not know. Summer asked if she could call or text. Lori asked Summer to text her. The following is the text string as it appears. Summer, an incident that supposedly happened to Brandon. Sounds highly suspicious. Lori, Brandon's Tesla or the Tesla company? Summer, Brandon's. He claims someone shot at him and shot the window to his Tesla a few days ago. Police are looking into it. Summer also texts, I think he is either trying to set Al up or making a future hit on Mel. Make him look innocent. No. I'm sorry. Gotta break in because remember how Summer cried on the phone? That recorded jail call between sisters? Think about it. JJ and Tylee were murdered September last seen on September 8th for Tylee, September 22nd for JJ. This is October 2nd when Brandon got shot at, and this is a few days after Brandon got shot at. So don't tell me she wasn't talking to her at the time.
Yep.
Just a few days ago. Police are looking into it. Summer also texts, I think he is either trying to set Al up or making a future hit on Mel. Make him look innocent, knowing him. But who knows, knowing him. Sounds suspicious to me. On page 315 of 1108, the conversation continues. Lori, maybe it was Edgar? Where is he? Summer. She sent a bunch of question marks and emojis with the male-female symbol. I doubt it was him. He wouldn't miss or leave witnesses. He usually makes things look like natural causes, but I don't know where he is or what he is doing. Summer also texts, he has a message to me on his Smule page, but I haven't responded. Summer then forwarded Lori an image of an unknown subject on music recording app Smule with the username of, quote, XZZYZX, unquote. It is suspected that this was Edgar. Searching Smule through Lori's iCloud account, I discovered that she was using this app to send songs or communicate with Chad Daybell as well. This was evident in the links that they would send to each other. And that is the end of that text string. So let me know what you think. Do you think that Edgar is a hitman? Do you think he is just Summer's old high school boyfriend? Do you think that the picture of Summer and Edgar is as recent as high school? It doesn't look like that to me. It looks like, a couple years ago, if that. So let me know what you think. And let's not forget, we still have a trial coming up in Arizona, and we want to get justice for Charles Vallow, my uncle, and we want to get justice for Brandon Boudreaux. He survived the attempt on his life. Alex missed. He did not hit Brandon, fortunately. And so according to Summer's message, the whole concerning part is I doubt it was him. He wouldn't miss or leave witnesses. He usually makes things look like natural causes, but I don't know where he is or what he is doing. Okay. Check, please. Anybody else have this problem in their family? I don't. Just throwing that in there. Oh, you're muted.
I thought he can't do anything right. I thought that's what I saw.
No, that was whenever he took the shot, whenever Alex surprised Tammy Daybell. That's when Lori was there in Arizona. No. Yeah, she was there in Arizona, and whatever she said, stupid, whatever, he can't do anything right. That was a So he at this point, or at that point, actually, at the time, whenever October 2nd for Brandon, October 8th and 19th for Tammy. 8th, unsuccessful, or it could have just been used to terrorize her, which Jason brought this point up to me earlier. He said he was thinking about it last night. This is what Jason does. So I'm just sharing it here. So, and I'm sorry, it's going to kind of discombobulate your brain a little bit because it did mine. But he was like, do you remember if there were 2 shell casings or 4 shell casings at this scene where Charles was murdered? And I was like, I don't remember off the top of my head. I remember them counting 4, but I don't remember exactly right now.
There
He
were
said,
only
what
2.
if...
There were 2.
Okay. Well, in the video, they do count 4. It's weird. You have to go back and check it out. But I'm saying that because Jason was like, what if 2 of those were blank? And I was like, for what? What would be? And he said, just to F with Charles. Maybe that's why he had the bruises on his knees. Like, I don't know if they, what if he was shot at just to scare him, to terrorize? That's what they do. They're sadistic. And I was just like, right. Cause I was like, oh God, that's so evil. If so, anyways, it's neither here nor there. And I can't prove it because I was not there. But yeah.
No, it's fascinating though, and I want to know 4 or 2. Like, I don't remember there being 4. So you're gonna have to hook me up with Jason. Like, me and Jason are gonna have to like.
He's fascinating. Yeah. I forget what I asked him earlier, and I was like, oh, because Megan had texted me yesterday. Where's my phone? And she asked me, kind of like what she presented last night to us was, she said, because I'd asked her if she wanted to do something a few days ago about preparing up people, not the people, preparing up people in the Firm Foundation, which was the organizations that Chad and Lori were involved in, as well as Tim Ballard and stuff. And so she was like, yes, I would love to do something with you about preparing people in latter-day media or whatever the hell they call themselves these days. She says, what do you think of the possibility that Melanie paid OUR $6,000 and that eventually went to Alex for Tammy? And so I told that to Jason, and Jason was like, well, I don't see it really, like them doing that to going through OUR and then laundering money for Tammy. But anyway, so I was like, well, just think about it. He was like, maybe for Brandon, but anyway, so he's stewing over that for what it's worth. He's just really good at strategizing and trying to think like a criminal, like they think, he's always like 5 steps ahead of me, and that's with 2 strokes. Okay. And I'm just like, wow.
Strategizing.
Strategizing or strategizing?
No, strategizing. That's
I've
what
never
he's
heard
doing.
that word. Did you just make that up?
I did.
Okay. Dude, you acting like Lori now.
Just making shit up.
Yeah, as you go. I'm grabbing that body cam footage of Charles being shot and seeing what I come up with. You do whatever you need to do now. Then I hijacked your damn live stream.
Have some too, but I don't know where it's at.
You have some to what?
Some body cam footage.
Oh, I have it pulled up. I just have to find the spot.
All right. That would be good.
I want to get the one of him inside, the police officer that went inside. I forget his name. Raz or something. Wiz. Let's see, that's not it.
Right. If you curl your mouth up just right, it'll.
Here it is. I found it. I found it. Am I still on there or no? Yes, I am. Okay.
Yes.
So let's see. Come on.
Come out this way, man. You know, no weapons? No weapons on me. All right, come on out this way.
You just believe everybody?
I'm gonna have you have a seat right here on the curb.
Yep. Hey, therapist,
No one else is in the house. Hey, just have a seat right there. Just get FB in there.
What the what?
Seat secure. We got the gentleman out.
With the what? Safe.
Scene secure? No, the scene is not secure. You have somebody who just admitted to unaliving somebody sitting on the curb in front of you.
And you just ask him.
The scene is not secure. It's not.
Correct, Joe.
Dude.
We're right there with you. These people have gotten the kid glove treatment over and over again. Nope.
Chandler Police Department, anybody inside, make yourself known.
Okay. So they're going to count in a little bit, and there's 2 over here or something. I don't know. I don't know if blanks do that. I have no idea.
Hold on. There was a dead guy laying on the ground to his right. Mm-hmm. To his right. There is a dead guy laying on the ground. The scene is not safe. The scene is not safe. This is, oh my gosh. Mm-hmm. Chandler PD.
Do better. Do better. One of the scene photos is unredacted. Oh my God. Whew. I ran across it.
For fuck's sake. Like, oh.
FFS.
Crap. I just swore again. I did it.
Oh, fuck it. Okay. Okay. We're adults. Well, now I can hear you. There's a gun. A gun. He only had 80 million of them. Oh, I'm sorry.
He's right here in
There's
the
the
living
black
room.
and white masonry.
Firearm's going to be
Checkered
in the
floor right there.
front door, in the front bedroom, laying on the ground next to a case.
Laying on the floor. It's not a ground until it's outside. Then it's a ground. Inside, it's a floor. She's the only one that had furniture. And her copy of Visions of Glory sitting on the nightstand. Okay.
We didn't have any of that as of right now.
How many times you gonna go? Round and round we go.
This happened right here, fellas? I believe so. The firearms in the other room here. What's up? I can't. What you said?
There's firearms in the other
I just
room.
did.
He just said there's firearms in the other room.
Okay,
what the hell? What
it.
the hell?
I believe so. The firearms
Like,
in
we're
the
gonna
other
let
room here.
Alex
Oh,
sit
the
out on the curb.
firearm is like, it's a contraction. The firearm in the other room.
Either
The
way,
firearm
one
is-
or multiple firearms. Like, why
He looked at it
is
earlier.
this dude sitting out on the curb, unrestrained?
No cuffs ever.
No.
Ever.
Oh
They
my-
actually just are like, Mr. Cox, can we get you some water? Can we get you anything else? Are you parched? You know, it is very frustrating. I just want to get the number.
I can't. What you said? Yeah, I just did. Yep. I'm gonna go see if we can get this. You want to stay in here? I'll see if I get this guy's info. 1, 2, 3, 4.
Right here. 1, 2, 3, 4. Let's pay attention here. Oh, shit.
You want to stay in here? I'll see if I get this guy's info. 1, 2, 3, 4 shots. Something like that.
See?
Maybe they weren't self-defense, you dumbasses.
And they knew that for sure as soon as they removed
Maybe
Charles from the home
yes,
because
maybe they
the
weren't
strike on the floor.
self-defense.
Right. He should have been arrested that day.
Oh my God.
It might have done all the difference in the world, but we will never know that because it went the way it did. But so yeah, I just wanted to know that. And so 1, 2, 3, 4 shots, he believes. It was just very interesting, you know. So now I can tell Jason what it's all for sure. And it is what it is. I mean, you can't, there's nothing we can do to change it, but we can analyze things. We can point out things that shouldn't have happened, judgment calls that they weren't qualified to make, like deeming Lori as not a danger to herself or her children by a police officer, and then telling her how to evade being held, you know, like reporting to community bridges. Uncle Charles he actually followed Gilbert Police Department's advice. He obtained the community bridges thing. He filed for a protection order. He did these things, and then they undermined him on these things. And so that's very frustrating. He's not a wife beater. He didn't hurt his children. He was just trying to get his wife help. I know it's not alone. It's not the police's job. They're just there to kind of ensure safety and all the things, you know, but don't tell somebody to do something and then renege on your own thing, like on what, anyways, on your own policy, procedure, and advice. You know, he did things right.
Yeah.
And that really sucks.
It does.
So,
it does. All right.
yeah.
I'm gonna head down to court in the morning. I'm gonna watch trials, jury selection.
We'll pray for you. We will. You and Trace, thank y'all for doing that again. I just have a whole new respect, for you who are just going as a spectator, even, and reporting back. Like she drains me, and I'm thousands of miles away, and through remotely. And so I just pray for protection and energy. Rebuke. Okay, just don't let
I
her.
will accept all that. Yes, I will accept all that 100%.
I don't know. I'm sorry. Huggy Bear asked if the mirrors were on opposing walls, because that is kind of like what they do in the temple, where it forms a portal, so to speak. Okay, so I know I didn't pay attention, but I've been wanting to. I do have pictures of this, but just quickly, I'll mute it. So there's one there. There's one there to the whatever. I'm looking at it. So one straight ahead, one to my right. And I think there is one. Yeah, you can see it in the mirror. Yeah. Yep. Sure can. Yeah. So yes, two of them are opposing. So
and they do that in the temple.
They do that in the temple. Yes. I didn't know that. And that is freaky when you do learn. You're like, oh, like I made a portal. But I mean, especially this group and their weirdness and obsession with portaling, aka remote viewing. It's a thing. And it's been discredited a lot, even by the 3-letter government agency. But if you go and research into the documents that they finally did declassify, you'll learn about vibrations. You'll learn about megahertz and frequencies. You'll learn about all the things that Lori, Zalima, Melanie, and the 7 gatherers were into. It's a thing. And so I don't know what's going on in the temple, especially where they went, because if you think about it, the Spring Thibodeau happened also in that same ward, where they were claiming that her son, who was a teenager, she like her husband, so Ben Thibodeau is his name, same ward that Lori and Zalima and Melanie and okay, so Bishop Gabe, Jason Mao, they all belong to. We're kind of doing the same thing where Spring and her brother took off they were found in Alaska, I want to say, and claiming that Blaze, the son, was a Jesus figure, I guess you could say. I don't remember right off the top of my head, but it was weird. And Lori Vallow's name was cited in court paperwork in that case too. So it's just like, what's going on here? I don't feel like an asshole for asking. I don't. I feel very like vindicated in doing so, or justified, should I say. So a ward or psych ward? You do your own research. You let me know. Because something strange going on. And then you have Brandon Boudreaux, who's also referring to Melanie Gibb as a recruiter. I learned that today earlier when I was listening to Megan read from the court, from the Gilbert police report. So just saying, we're not crazy and coming up with these same things,
Well, I will never come to the determination that I'm not crazy, but I will try to come to that.
You're not their kind of crazy. You're not. Their crazy does not equal you're crazy. You sound crazy for researching and reporting on their crazy. I swear to God, I've been like, oh my God, now I know how kind of I'm not replacing my uncle's experience because, oh my God. But I've so many times been like, oh my God, this is how Uncle Charles, he must have felt so, he was looked at like he was crazy.
He must have felt so much by himself. That's what gets me.
And
by
because it's
himself.
so in speak, that inside speak. He was an
Yep.
outsider, even to his wife in his own church system and their belief system.
Yes.
And he was shunned by the stake president, by the bishop, by the police, by all the people. So
He was trying to do it right. And the system, both
let him down.
systems,
All of them, ecclesiastical and judicial, the law system. Yeah. And the Cox family system let him down.
Yeah.
Completely. So here we are. All we can do is do better. Point out things that don't look right, don't feel right. Trust your gut instinct, okay? That's the moral of the story.
Charles. We're trying, Charles. We are.
So many things to talk about around the unraveling of this case.
Right.
They shouldn't have gotten as far as they got, but all these things enabled them to do more harm to more people. So anyways, thank y'all for being here. I appreciate that. I appreciate you for having me on again. I even debated when I woke up. I was like, oh God, I'm just so tired. But then I started to feel better and kind of get my head about me. So thanks for...
We got it. We got this together. We got it together.
That's it. Thank you for helping me with that burden on my shoulders. It does help a lot. And everybody here helps alleviate that weight, I guess you could say. So we're here for Brandon and his children. They deserve the truth, the whole truth, and nothing but the damn truth. Okay. About their mother and their aunt and their uncle, great aunt, great uncle, whatever. And the Cox family, who they still get to go visit. The system is broken. Okay.
Justice for finish it out.
Kylie, Charles, Tammy, JJ, and Joe, and Brandon. Okay. Love always wins. You guys are proof of this. See y'all tomorrow. Love always wins.
Good evening. Come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. Good evening. Come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime. We can make a difference if we put in the time. If we put in the time. Good evening. Come and find you a seat. Grab yourself a cup of joe and put up your feet. Let's talk about the latest news and all about true crime.